our special guest speaker is Karl Lentz. You've seen him in the chat, I'm sure. He's a madman. He's very opinionated, and I told him he could have the floor tonight, so, because he's always, writing all kinds of stuff, wanting to get his 2 cents in, so he's got the opportunity tonight. There's 2 hours he can kill, just telling us what he thinks. Hello, Karl.
Hey, Angie, how you doing?
I'm fine, thank you. I hope everything is good where you are.
Good.
What are you going to tell us tonight?
Well, I've been getting some emails from, I think that's Tom Murphy. Somebody's been sending me emails saying that they feel Granny on the audio log, and she's had a granddaughter taken from by CPS or DHO, call it where she lives. And I was just trying to help folks who are trying to get their child back, because my child was also taken for social services years ago. And it took me 11 years to get my child back. But finally,
how many years?
It took 8 years to get him returned.
Isn't that amazing? Oh,
yeah,
God.
I'll give the story real quick what happened, because I could do it fairly quickly.
Okay.
What happened was the baby was born with Downs, so if anybody knows anything about Downs, most children are born premature. So my wife was down in Alabama visiting her mother, her family, but we were going to have the child up here in Virginia, because all my medical coverage was up here in Virginia. My folks have a farm in Stewart Strath, just on the other side of Charlottesville. And when she was visiting her mother, she went and got a sonogram while she was at the local hospital down there, because she felt funny. So the doctors said, the baby's ready to come out. We got to pull him out. My wife's like, no, I got 2 more months. I'm like, well, I don't explain to you. He wants to come out. So they pulled him on out, and then my wife called me up, and I was doing some fiber optic work up in the Carolinas. And earlier my wife worked as a law clerk, and she worked as a medical transcriber. So she was intelligent. She wasn't some sort of like some booze head who just hung out on herself and watched Oprah all day. So she's an intelligent woman. And she called me up, and I came down, and a couple of days, since he was premature, they said he's going to have to stay in the hospital for about an extra month, because he's really going to 1-2 pounds 10 now. So what happened was, while we were in there, about 3 or 4 days after he was born, a couple of social service people came to us, and they said, well, how are you going to provide for the child? So my family lives in Virginia. My sister works for the School for the Deaf and Blind. My mom's a federal agent for the IRS for almost 30 years. She's a tax auditor. So we think we got it covered. And they were like, well, we need you to fill out all this paperwork. So the kid could get Medicaid and Social Security. I said, ma'am, I don't need any government aid. I said, I'm fine. I said, we got it covered. And they were like, well, he still has to apply for all this stuff. And I said, no, man. They said, well, the bills can run in the millions. I said, man, we're fine. We know how to handle a bill. And they said, well, you're not going to be able to take him out of the hospital until you sign all this paperwork. And I said, am I under arrest? And she was like, no. I said, my wife under arrest? And she was like, no. I was like, did me and my wife commit any crime to a child? Are you saying that we committed a crime? They're like, no. And I said, well, then how are you going to keep the child in the hospital if we don't sign the paperwork? And she said, we do this every day, Mr. Lentz. I said, is that a threat? And they said, Mr. Lentz, that's a promise. If you do not sign this paperwork, you are not going to have the child released to you from the hospital. I said to my wife, I said, you still friends with your lawyer? Snable and Snable? She said, yeah. I said, ma'am, can I have that contract, and can I bring it to my attorney, my wife's attorney? And she said, he's going to have to come here and talk to us. I said, this is getting silly. I said, you know what, ma'am? When you have a copy of that contract ready for us, you let us know. And she said, if you don't sign it now, when you come back tomorrow, this was August 13th, 2001, if you come back tomorrow, the child's going to be gone. I said, ma'am, you better not touch my child without my consent. And they were like, well, you better sign the paperwork then. My wife just got on the elevator. They chased us down the hallway with the paper saying, sign it. They said, have a nice night. The next morning, we showed up 7 o'clock in the morning, and he was gone to feed him. My wife rented out a breast pump because he was so tiny. So we came in 7 o'clock in the morning before I had to go to work, and the baby was gone. I asked the hospital staff, where is he? And they said the social services came and took him. And I said, wait a second, where's the pickup order? They said, they didn't give us one. I said, you just let somebody take my child without a pickup order. Oh, well, they said, we know the social workers. I said, ma'am, I said, there needs to be a court order. And they were like, well, you need to leave the hospital now. There's no further business for you here. The child's not in this building. You need to go. So then obviously we did went down to the courthouse and tried to get a copy.
Wait a minute. They just took the child
Yes,
because you didn't want to sign the paperwork?
Yes, ma'am. Oh, this is a really funny story. So, like I said, we did the normal thing. We went, got the attorney, and we tried to go to court and everything like that. We tried to see if we would charge for the crime, but they would never give us a copy of the case file. So me and my wife, we hired 9 attorneys, and over 8-year time, we could never get a copy of the case file. So over 8-year time, we could never get them to say in open court why they were holding the child. We'd ask them in open court. We'd say, have me and my wife committed a crime? And the state would say, you know what you did. And I was like, no, I don't know what I did. Oh, this is, like I said, it's all in my lawsuit. I'm not lying because this is all going into the federal district court tomorrow. I tried to submit it here in Roanoke, Virginia, but they said they weren't going to ship it down to me. So they said, you're going to have to ship it yourself. So we're going to ship it ourselves. So everything I'm saying is true, because if it's not true, I'm at the U.S. Marshal Service and for a writ of sequestration to take the DHR to the District Court Control, and I'm suing them for $346 million. So if I'm lying, I'm going to jail. So you better believe this isn't a fairy tale, because I'd be in my mind to be doing all this stuff in a federal court and lie. So what happened was, it took, like I said, we went through 30 trials. So finally at the last trial, they sent Judge Owings from Bibb County. He was appointed by the Alabama Supreme Court, because all the judges kept recusing themselves. Well, to 9 judges. So he finally took it over. So I asked him a simple question when I first started. I said, look, there's only 2 ways you can invoke the jurisdiction of a party, right? He's like, yes. I said, it's either we were committed with a crime and convicted, or we signed a contract. So the Attorney General's office man is standing right there, Jonathan Schlangner, Deputy Attorney General. Now, they sent the Attorney General down, the Deputy Attorney General down here to do this case. So I said, Mr. Schlangner, I said, state. I said, have me and my wife have been charged with a crime in the state of Alabama? I said, no, sir. Have we ever been committed or charged with abuse or alleged to have done any wrong to a child? He said, no. I said, okay, see that, Judge? Watch this. Now, there's only one other way that you can have this child. I said, there must be a signed contract between the parties saying that we did not want the child because he had Downs. He said, that's what you and your wife did. I said, oh, really? I said, where can I find that contract? He said, sitting right there in front of the judge in that case file. I said to the judge, can you get me a copy of that contract sitting right there in front of you? He says, well, you and I looked through it the other day, and we couldn't find it. And I said, now, tell the state, make the state produce the contract. And he says, state produced the contract. And the state said, it's not our job. But at the time of the signing of the contract, he got a copy, and we got a copy. If he lost his copy, that's none of my problem. So I said to the judge, I said, you see the nonsense that we're dealing with here? So he says to me, he says, well, you know administrative law, don't you? I said, yes. Preponderance of evidence is 51% on the state. I've got to convince you of a negative, which will never happen. So the judge said, well, try. Go ahead. So he let me talk for about 6-7 hours straight. So for a dad to stand on a DHR CPS floor courtroom and be able to speak for 7 hours, the judge gave me every chance to convince him that the state was lying. But he said, until you can prove that that contract that's in this case file, that the state claims is in this case file, I can't do anything to help you. So he said to me, he said, look, Karl, let me pass the final judgment on this case. And he says, do you know how to file an appeal? I said, no, sir, I do not. He said, well, come here, approach the bench. So he gave me his business card. He says, now, go wait out in the hallway. Let me wrap this up, and I'm going to go out in the hallway, and I'm going to show you how to file an appeal. So the judge was really nice. He says, then when I got in the hallway with him, he called up the head clerk of the court at the Alabama Supreme Court, Mr. John Wilkinson. And he told Mr. Wilkinson what I'm going to need. He said, this man hasn't been able to have access to the case file for 8 years. I let him look. Me and him went through this ourselves, a month ago, and we couldn't find any contract in here that they were talking about. So can you do us a favor? Can you try to find this contract? So that's how that ended. So Mr. Wilkinson did find the contract. And he's like, holy cow. He said, I think I found a contract. I said, where? He said, it's on page 40, 41, and 42. I said, what does it say? And he starts naming all these people out. And he said, I don't know who, he names like a little old lady, a 3-year-old girl, and an uncle for a girl who's staying in an apartment. He said, that has nothing to do with me. I said, oh my God, the state didn't lie. There is a contract in that case file, but it has absolutely nothing to do with me. So, yes, they were telling the truth. Yes, there is a contract in that court case file, but it So then I called up I was writing a appellee reply, I was writing a brief to appeal the judge's decision, the final order. And I warned the Attorney General's office. I called them up. I said, who's writing the brief on this case? And he told me. So I told him, Mr. Nunley, I talked to him. I said, I'm warning you, don't use page 40, 41, 42 in your reply brief to me. That is a forged instrument. That's a false document. If you do it, I'm telling you, you're going to be holding yourself liable. So he asked me, he says, are you an attorney? I said, no. He says, well, I'm an attorney. I think I know how to write a brief. I have 2 more to do before I write yours. So have a nice day, Mr. Lentz. I said, well, I'm just giving you a fair warning. Don't use it. So on July 3rd of 2009, I got my copy of the reply brief, and it said that page 1, on line 6, 7, and 8, it said that parents agreed with the state of Alabama to place the child in foster care division. And then it says on page 4, it said the mother signed the child into the state's custody, see contract, page 40, 41, 42. So it's like, holy cow. So then I called him up. I said, do you realize what you did? I said, I've been waiting 8 years for somebody to tell me where this contract was. He says, well, that's what the contract. I said, I told you don't do it. I said, I recorded you. He said, you did? I said, yeah. So then he said, what's it going to take to settle, Mr. Lentz? And I said, honestly, I don't know enough about the law in which I'm allowed to ask what I may ask for relief. So he goes to me, he said, well, when you know, I said, when I know how to give you a lawful answer, I'll let you know. So that for the next 2 years now, I've been in the law library. I just came from the law library a couple minutes ago. And I basically wrote a dictionary encyclopedia, so I made sure I asked them correctly. So it took me the longest time. So Gordon Hall helped me with one part of it. He said to me, I said, look, if I'm suing them for a lot of money, and they come at me and they say, look, we'll give you $1 million. What should I do? I said, I could use the $1 million. What do I do? And he gave me a great answer. So this is a great answer from Gordon Hall. He says, I conditionally accept your offer of $1 million, but that does not negate the fact that there's still an outstanding balance between us. So he said, that way you can still take the money, but at least you have enough.
You're leaving it open for the rest. Yeah.
Right. Because I've seen what happened in a case was called Rayleigh versus Maine. It was an Alabama case, and the game warden shot some man in the back. So he was found guilty, and I think he's either in the state prison or federal prison. So the widow of the man who got shot in the back, the game warden tried to say the man was going for a gun, but he was just going for his driver's license, like the game warden told him to give him. So he shot the man in the back, and they had video cameras, so the game warden's in the jail. But anyway, the widow, I'm not sure exactly how much she asked, but she asked for like $1 million. So then what happened was, you folks got to be really careful when you make a wish for, like, say, $1 million, because that's what they asked. They said, what are you wishing for settlement? So the judges use those words. Wishes are very powerful. So when she was made an offer of, like, say, $500,000, she accepted. And as soon as she accepted, her $1 million claim to be made whole and complete was deemed to be fraud. Because if you say to be whole and complete will be $1 million, and then they come back with a counter offer, say $500,000, and you accept it, well, then your $1 million claim is a false claim, and then every part of your claim gets thrown out and dismissed. So I don't know if she ever got any money at all, but I'm warning you folks, when I read the case, I was like, holy cow, because if they gave me a lower offer and I accepted it, my whole entire claim would have been thrown out. And how I try to explain to people is like, say, National Geographic was giving somebody a $1 million prize for discovering the South Pole. Who's ever on the South Pole first, like, say, 100 years ago, gets $1 million. So if Admiral Byrd went down there and he said, well, I discovered the South Pole, I put a flag there, here's a photo, and give me my $1 million. What attorneys try to do to you in court is they try to play the word reasonable. So he's like, come on, it was cold, it was 30 degrees below zero, come on, are you sure your compass really read zero? You know, come on, maybe you were off by 1 millimeter, come on, be reasonable to this jury now, not be reasonable. Tell us the truth. Maybe you might have been off by maybe a micron, maybe a millimeter. And if he says yes, then he said he didn't hit the South Pole. So what you would have to do is like, no, that is my word, and I'm sticking to it, unless a man can come forth and claim that my claim is a false claim, that I did not hit the South Pole, then my claim stands as true until somebody comes here before the National Geographic Society and says that I filed a false claim. Then you could sue me to get the $1 million back. But until then, I want every damn dime that you said is the prize to hit the South Pole. I hit it. Anybody else wants to claim I didn't? Bring your claim forward. But until then, I demand the money. So attorneys try to play this reasonable nonsense with you. So whenever you hear an attorney say reasonable, run like hell. because that's how they get you to say from. It breaks your word, because your word is your bond. And if you move one iota off of your belief, and they could move you off your standing, they can knock you off your pedestal, your whole entire claim gets thrown out the window. So just stick to your guns, and when they say something, just say, that's my word and I'm sticking to it. So like I said, my claim is going in, and like I said, I just printed out some orders, and the orders are really simple. Like I try to tell people, I said, like, one order is just say, it is the order of court. When you say it is the order of court, court means me, or the jury, and the defendant. We're the court, not the judge, or the clerks. It's the order of court. You don't hear the word this court. It's just court. That the state of Alabama's court case stylized as JU 2001-51832 is to be known to the world as void ab initio, and all of its subsequent orders are to have no force of operation. So that's how simple an order has to be. It doesn't have to be elaborate. It doesn't have to be huge. It's a nice, simple order. And I'm just basically saying I want the world to look at this case as a false case, and that every subsequent order that came from this case is to be noticed as void, or known as. You don't want to use the word deemed, because deemed is a legalese word. And every single thing I write, there's not one legalese word in it. So when they try to come at me with legalese, I say, well, you're pro se. I say, no, I'm not pro se. I don't know what that means. Where can I find that in the common poems? Where can I find that in the common term? I'm not pro se. I'm just a man. And if you try to diminish my standing, if you try to knock me off my pedestal as a man, I can't accept that. I'm just an aggrieved man. Aggrieved just means somebody who's lost his rights, and he wants his rights back. So I'm just saying I'm an aggrieved man. And like I said, if you look at the very first page of my lawsuit, it just says, like where you usually put up the caption where it says plaintiffs and defendants, it just says, in lowercase, it says, a man, colon. I'm not sending you the stuff, I just sent you the stuff so you can post it online so people can see what I'm talking about when you file a lawsuit, how to stylize it. So like, it's lowercase, a man, colon, and then Karl Rudolph Lentz, comma, the aggrieved party, semicolon, prosecutor.
Okay, wait a minute though. Is this case, this is a lawsuit, but you already got your child back, right?
Ma'am, no, this is just for the monetary compensation.
Okay, what did you use to get your child back?
Once we found out that the child was, the contract was like a fake contract, they immediately gave the child back.
Ah.
So, but it's like, well, what do you want for compensation? I want money.
Okay.
That took me years, so I got a really funny thing that I decided to do. So how I was going to sue for like $1 million, $2 million, $3 million. I don't know. Me and my sister, we just throwing numbers around. Nothing made any sense to us. So finally, I had something that made a lot of sense. I said, look, if somebody took your child out of the hospital for even 1 second, would you think at least minimum of $1 for compensation would be fair? Most people would want $10,000 because you took their child out of the hospital for 1 second without consent or without any right to do it. So I said to myself, hey, you know what? That's great. If I have to speak to a jury, I said, look, if somebody took your child out of the hospital even for 1 second, is $1 fair? And everybody said, well, no. $10,000, $1 million would be fair. Well, let me just say I'm a fair guy, and I'll say $1 for every second they interfered with my right.
Your child was kidnapped.
Right. So what I said is, that's why I said, I figured out there was 346 million seconds that my rights were interfered with. So I'm going to charge them $1 for every second that my right was interfered with. So if they wanted to do it for 1 day, they would have got sued for a couple $100. They want to do it for a week, it'd be a couple of thousand. They want to do it for a year.
Now, did you put that formula, how you arrived at that amount in your paperwork?
Oh, I certainly did. So that's what I said. It's going to be funny because, like I said, it's like 1 second equals $1. 1 minute, $60. 1 day equals, it was like $36,000 or $8,000. I forgot what it is right off the top of my head. But that's what I'm saying. I thought that was cute. I was like, oh boy, that sounds reasonable. $1 for every second my right was interfered with. That's good. I like that. And that's a big thing I did wrong. First two sides.
Wait a minute. Your sound is going in and out. Are you moving away from the mic or something?
No, ma'am. I'm just on a cell phone.
Oh, okay.
So it was funny.
Talk slower, maybe a little bit.
Okay. I did file 2 lawsuits back in 2003 and I think 2006 in the federal court. I was just trying to get a copy of the case file so I could find out how they took my child. So what I realized, the number one thing I did wrong is I used code. And I used code like crazy. I studied all their code books, and my whole entire lawsuit is based on codes and citations. So what kept happening is they kept 12b6 in me, and I did not know what a 12b6 meant. And so I just failed to state a claim which the court could grant relief. I said, well, what is this? I thought I did. So it took me years to learn out what a 12b6 is, and a 12b6 is very simple. It's saying that they agree with every single fact that you are saying. It's just that you're not providing them the law in which the court can invoke the jurisdiction of the power over the other people, over the other party. So, like I said, what I was doing, I was using Title 42 and like a 1983 civil rights claim. So what the problem was is if I was asking for something that Title 42, Section 1983 doesn't allow me to ask for in a form of relief, that's what I did wrong. So I either asked for more than $500 because 1983 says you can only ask for $500. And 1983 doesn't say anything that they have to be forced to give over a case file. So when you use their codes, if you don't use it exactly how it's written, they're going to say there's nowhere in the 1983 Civil Rights statute that says anything about us being able to force the state to turn over a case file. So I realized, oh my God. And then the second lawsuit I did was even funnier. They knew I was going to sue, I was going to do a third one in 2008, 2009 after the final judgment. So I started writing my lawsuit while I was writing my brief. And they changed all the codes on me. So when I went to go submit my lawsuit again under code, 2009, I went back and I checked in June to make sure all my codes lined up. Well, the judge made the judgment final on December 15th of 2008. On January 1st of 2009, they changed all the codes that I was using to where I submitted my lawsuit would be all gibberish because none of the codes matched.
Oh,
and I warned everybody. I said to them a couple weeks ago, I said, look, now when Barack Obama wins again, 2 conservative Supreme Court judges are going to leave the bench. He's going to put in 2 of his buddies. So the whole image of the Supreme Court is going to be extremely socialist or liberal. So if they want to, there's nothing in the law that says that the United States Supreme Court can't just overturn every single ruling they've made for the last 220 years. So I said, I warn everybody, I said, you better be careful. If you're thinking that the Supreme Court of the United States is the highest court of the land, it's the highest court of the United States government, but it's not the highest court of the land. I said, so all your citations that you folks have been working on for the last 10, 20, 30, 40, 50 years, however long you folks have been alive doing this stuff, are all going to be thrown out the window. So, and they're all going to be useless because they say, well, no, the Supreme Court ruled in 2013 that, it's like, what? When did they do that? Barack Obama put 2 more people in there and they just overturned it like 100, 200 rulings. Well, that's ridiculous. Well, that's the new law. That's the new rules. Everybody's got to move this way now. I was like, no way, I'm not doing this. So like I said, that's when I found Billy Thornton. Mr. Thornton's the common law man, and he's great. The only problem I see with Mr. Thornton, if he's listening, he's a great guy, I'd love to hang out with the guy, but he talks too much. He talks to the judge too much. I think he wants the judge to respect him. I think he wants the judge to like him. And me, I just say, Judge, you have an oath of office. You have a duty to function here. You're here to perform a duty. You move under Article 6, Clause 3, and you took an oath to uphold the Constitution. You're bound by that oath, and I'm going to hold you to it. So my job is to create orders, and your job is just to see that my orders get stamped and get delivered to the other side. That's all I want. And once the other side has 21 days to either accept the order or appeal the order, then we'll come back and we'll have a common law court of record trial where the jury will be the judge and they'll determine the facts and they'll determine the law. I don't need you in any capacity whatsoever to judge anything. I didn't go to law school with you. I'm not in the same yacht club with you, so I don't want to have you to have any part of the picture. I don't want anybody in a black robe who thinks they're better than me to determine whether my case is merit or not. Is there some reason why I can't just have a common law court of record before a trial by jury that the 7th Amendment says right there in the Constitution. And you took an oath of office, and you're bound by it. Now, like I said today, I had to submit a summons for them to appear. And my summons is very simple, but like I said, you got to be very careful because I basically used their template. But like I said, you can see how different I did the template compared to how they did their template. And now I'm moving. So if the name sounds silly, here you go. On the header, that says the United States District Court. Well, obviously, I don't want them to be summoned before a United States District Court. I want them in a federal district court. So what I did is I basically cut, copied, and pasted their form. Because when they see it, it's going to be like, oh, it's stylized just like we do it. It's like, that's right, it looks exactly like your folks' stuff, doesn't it? So, like I said, I'm just opening up their summons, what their summons says, and I'll show you the difference, how I modified theirs. But like I said, it's a good idea to use theirs because it's like when you pay a bill to a cell phone company. They just run your bill to a machine. Nobody actually opens up your bill and reads it. You know, some people are doing that accepted for value nonsense, and that's where they're getting away with it because they know nobody's really going to open up the bill, whatever you send back to them, and read it. So they're like, well, you accepted $1 on my check, and they said that I know the balance is now, there's no more balance between us. And you can't do that nonsense. But I know they're going to be looking at my summons, and if it's stylized exactly like theirs, they're not really going to catch it. Because their summons right off their website says United States District Court, all that uppercase nonsense. And then it says civil action number. And then it says summons and a civil action. And then it says to the defendant. And then it just says a lawsuit has been filed against you. Within 21 days after service of the summons on you, not counting the day you received it, or 60 days if you are a United States or United States agency or an officer or an employee of the United States described in Federal Rule Civil Procedure 12, or 90 days in a Social Security action, you must serve on the plaintiff an answer to the attached complaint or motion under 12 of the Federal Rules of Civil Procedure. The answer or motion must be served on the plaintiff or plaintiff's attorney whose names and addresses are here. So mine looks almost exactly the same, but mine is much simpler. Mine just says within 21 days after service of this summons on you, not counting the day you received it, you must serve on the prosecutor a verified answer to the suit, or make your wish known to the tribunal that you want court to try the matters on day 22. So the whole thing with mine saying a verified answer, only a man can give a verified answer. A certified answer comes from an attorney. And like I said, my court case file is certified. And all the court orders in there are supposed to be certified. But like I said, when the clerk of the court for the Alabama Supreme Court got a hold of my case file, he said, this is the most tampered, mutilated court case file I've ever seen in my life. He says, you know what, sir? None of these court orders are time-stamped. I said, what does that mean? None of them went to the clerk of court's office. And he says, it took me all weekend, it was Memorial Day weekend, it took me all weekend to find the first court order. I said, where's the first court order? He says, well, the first page of it is on page 48. The second page of your court order is on page 70. The second court order is on page 8 and 9. And he says, you know what comes on page 10 to page 30? I was like, no, what? Your mother's flight travel itinerary for 2007. He says, there's 20 whole pages missing from the beginning of this case file. He says, I had no idea what I was looking at here. So I said to him, so, you think the state of Alabama kidnapped my kid? And he's been doing this since 1975. He said, well, I can't tell you what I think. He said, but I've never seen that. He said, he is a deacon of a church. He's a member of the Kiwanis Club. He's the president of the Clerk of the Courts Association of America. And he teaches law at his Troy University down there in Montgomery since 1974 to be a clerk. And he's like, I've never seen a case file that looks like this come through my office. I would never believe something like this could exist. He says, and the 6 years of court case files, the 6 years of court orders I see in here after March 12, 2002, I can't even find March 12, 2002 court order. I said, well, I got a copy of it. He says, that's ridiculous. How could you have a copy of that court order and the clerk of the court doesn't and we don't? And every old court order was based upon that. I said, well, I got a copy of it. I said, my friend was a attorney, then he became a judge, and he got me a copy of that court order. He said, this is where it all started from. He says, I went to the judge's chambers, and I dug through the thing. He said, this is the court order. And I said, he gave it to me like 5 years ago. I said, so he was my attorney, but like I said, once he became a judge, he went in there, he said, I'll find out what the hell's going on. So he said, this is what it's all based on, Carl. This is the best I can do. He said, I don't see any contract anywhere. He said, but You want to see what they claim is the first court order? It's March 12th, 2002. And then Mr. Wilkinson told me, he says, no, Karl, there's 3 more orders before March 12th. He says, but everybody's basing it on March 12th. I said, well, sir, I got a copy of it. He said, this is ridiculous. He said, you know what? It's illegal for me to digitize a child's case file and email it. He says, I'll digitize it and I'll email it. I'll email it to anybody you want. I thought you said it was illegal. He says, I'll explain to whoever that why I did what I did. He said, because when I explain what I'm looking at right here, he says, they're not going to come after me. So like I said, that's how I did my summons. It was very simple. I gave you folks a copy of it, so you're going to love it. Because like I said, you want them to do a verified answer to the suit. So only a man can answer it. So like if I'm suing the governor and the attorney general, because the deputy attorney generals moved the case through the court. So the attorney general is liable for his subordinates. So the reason why I said I want a verified answer is because if anybody else submits an answer to the court other than the attorney general or the governor, it's not verified. It didn't come from the person I'm actually suing. It came from some attorney. An attorney can't give a verified answer. Only the governor can. Only the man that I'm suing. So like I said, when I stylized the governor, because most people don't know this either. There is no governors in the United States. So if you read my lawsuit, it just says Robert Benton, Chief Magistrate. Because the Chief Magistrate is, because you can't have any titles of nobility in this country. So the problem with the titles of nobility is, like I said, with the Constitution, I'm trying to open it up right here for the Constitution of Alabama. It says, I think it's in section 113, he can be stylized as the governor, but he cannot be, there is no, like I said, but when I get that, so like I said, because people can say, oh, this guy's crazy, there's no governor. There's a governor in my state. It's like, well, if you actually read your Constitution of your state, here it is. 1905. Let me scroll down to the governor. Here you go. Article 5, the Executive Department, Section 113, Supreme Executive Power vested in Governor. The Supreme Executive Power of this state shall be vested in a Chief Magistrate, who shall also be styled the Governor of the state of Alabama. Now, he's styled. He's stylish. He's an accoutrement. He's like a button or a lapel pin. But he's styled as the Governor. This executive supreme power of the state shall be vested in a Chief Magistrate. And if you actually etymologize the word magistrate, a magistrate was just a guy who went around and made sure all the water glasses and wine glasses were full at the king's court. The magistrate was a flunky. So, like I said, that's why I actually took apart every single word, and I etymologized, and I wrote a dictionary. And that's why now when I'm looking at a magistrate, or a man in a black robe, I look at him as a magistrate. It's like, look, you're a busboy, you're the waiter. You run around and make sure everybody in court is happy. That's your job. I'm the moving party. I'm the prosecutor. And like I said to people all the time, when people say the sovereign nonsense, I'm like, look, if you go into, I'm trying to remember that off the top of my head, here you go. It's 2 Danville, Section 259. It says a court of record is free to the king and his subjects. And I say to people all the time, look, I don't care if I'm the king. I don't care if I'm one of his subjects. As long as I can get into this court for free, that's all I care about. So that's why you can't have a title of nobility. That's why it's not a governor of a state, because that's an English word for like somebody of nobility. Governor, like you watch a pirate movie, it's like, oh, the governor of Jamaica is going to go after Captain Blackbeard, the governor of Jamaica. That's a title of nobility. So most people think, oh, there's a governor. So when I hear people say governor, I just laugh. I go, no, he's the chief magistrate of the state. So like I said, and then like I said, how I ended the summons. Like I said, I think it's a great summons that people would just cut, copy, and paste, because nobody's going to really read the damn thing. They're just going to, think, oh, this is another summons. Get my attorneys on it, chop, people start working. So like I said, in the bottom I said, if you fail to present a verified answer, a judgment by default, or nil, what's in your lie, a set judgment will be entered into the record against you, and the immediate execution of the orders within the suit will commence upon date on the 22nd day. So it's just that simple. Because when people say a default judgment, most people don't know what a default judgment is. A default judgment means just the man just didn't show up. So basically, they could basically hold your order in abeyance or stay your order for 7 years until the body appears. Or the man can come back within 7 years and say, oh, here I am. I just fell overboard. I made it back to land. Somebody has a judgment against me? Oh, well, let me have the trial now. So the big thing is it's called NIL, DICET judgment, a null dissent judgment. And all that means is you ask his attorney, he's like, do you know where the governor is? Yes, I know where the governor is. What did he order you to do? Well, he told me to fill out this lawsuit. Okay, did he sign his name? Is he going to verify everything he said here under oath of affirmation in open court? It's like, well, what do you mean? It's like, if he won't, I'm going to get a null dissent judgment against the man because he didn't give you any orders. He didn't tell you what he was going to do, and that's what it just means. He didn't instruct his attorney what to do on his behalf. It's like, did you just do this all on your own, Mr. Attorney? Well, yeah, he's a busy guy. This tornado is down here and there's floods. So he didn't actually sit down here and write this out with you. No. Really? So he didn't give you any instructions? No. So can you verify this in open court and oath of affirmation on day 22? Well, no. So, today's day 22, Judge, clerk of the court, person in black robe. I want you to execute the orders immediately. He had the ability. I summoned him, and this is exactly what the summons says. Is this summons illegal or unlawful? They'd be like, well, no, that's just not the way we normally do things. It's like, so, do you normally kidnap kids? Well, no. Well, then there you go. This whole case is not normal. So here we go. So like I said, that's the whole trick with all this stuff. So when I hear everybody using Constitution kind of stuff, and, yeah, we have rights, but the rights are protected and secured by the Constitution. We just try to force the man to, the man in the black robe. The whole trick is to get him to make him perform his duty under the Constitution and to secure and protect your rights. Because Mr. Hall got into an argument with me about 2 weeks ago. He kept saying to me, well, if you're in an arraignment, I say, you guilty, not guilty, no contest, what do you say? I said, well, I've been arrested before. And when I go before an arraignment, a public defender comes and talks to you, and they say, well, this is the charges against you, and you're going to go now before a magistrate, and they're going to enter a plea. Would you like me to represent you? And I said to them, to Mr. Hall, I said, no, I would just ask the public defender, can I please have a writing utensil, a piece of paper? I don't care if it's a pen, a crayon, a pencil. Let me provide an answer for the magistrate. So when the magistrate brings me in there, I'll say, did you not look at the notice I gave to this court? And then the magistrate will read the notice, and the notice will say that is there a verified criminal complaint before this court? If there's not a verified, I don't care about certified, if there's a verified criminal complaint that I've done a man injury, can you please stay court for 72 hours so I can compensate the man that I've done wrong of his injuries? And after 72 hours, then I'll be glad to come back and if I could not settle with the man that claims that I injured him. But if you don't have a verified criminal complaint, you have no case since you have no injured party. So it's like, well, I said to him, I said, look, I don't care if it's cocaine trafficking, I don't care if it's machine guns, I don't care if it's anything. Who's the injured party? And Mr. Gordon Hall started going bananas. He's like, oh, no, I want you to say guilty, not guilty, no contest. I said, sorry, I already answered you. And once I open my mouth in court, like Billy Thornton says, once you open your mouth in court, anything you submitted to the court before the second that you open your mouth gets all thrown out the window. And now you're starting a whole brand new contract with the judge. So you just say, look, do you not have what I wrote to you in front of you? It's like, well, yes, I do. I said, well, that's all I have to say to the court at this time. And he said, that judge ain't going to let you get away with that. He's going to say, I said, I already answered him. I said, and if he wants to hold me, he can hold me. But then what you write there is, so if you hold me, if you want to enter a plea for me, I'm going to charge you $10,000 a day for every day you hold me in here until an injured party appears. If an injured party doesn't appear, the clock is ticking. I'm going to charge you. Just like I said, I charge him. I figured it out the other day. I said, oh, let's do 1 second for every minute, $1 for every second you interfere with my rights. The clock is ticking, Judge. Well, what's your wish? Because wish is a very helpful word. Because I learned that by reading the code book of Alabama when it comes to social service problems. It said that if you signed a contract, that's what they say, that granny lady, if somebody signed a contract with social services to have their child placed into foster care, it is as simple as, I don't know the code off the top of my head, but I'll put it on the internet. If you wish, it says if the parents wish to have the child returned to them and the child was placed into custody, not under a crime, not under a conviction, if the parents wish to have the child returned to them based upon a contract with the state, the children or the child is to be returned to the parents immediately. But you have to use the correct word. You have to say, I wish to have the child returned immediately. Because people say, well, I want my kid returned. That's not a wish. Only a man can make a wish. So until you make a wish in court, I love listening to somebody the other day. The judge lady was slamming the guy's like, do you wish to be sentenced? And the guy was like, no, I really don't know. Oh, it was on YouTube. I just laughed at the poor kid. I was watching YouTube thing. The judge is asking, do you wish to be sentenced today? And he was like, well, do you want to just come back again and sit in court again for another 3 or 4 hours? Or do you wish to be sentenced? So watch these YouTube videos really closely, and you'll see the judges use the word wish a lot. Because only man's allowed to make a wish. And once you get a wish, it's going to be granted. Because that's what the judge is there to do. To grant you your wish. You order the judge around. And you say, well, that's my wish to be sentenced. And he said, good. Now the judge will sentence you. But like I said with that granny lady, I'm trying to remember what that man was asking me. I said, most people won't get their kids back. I said, because what I try to tell people to do is way too simple. And people just don't want to believe it's that simple. They want to believe they have to get a lawyer. They want to believe they have to do all these anger management classes or parenting classes. Or if the child was taken into custody, and this is under the Social Security Act 672, subsection F, under Title 42, and it's under the Medicaid Act 472, subsection F as well. It also states exactly what I just said. That if this child is taken into the state's custody, the parents must approach the state. The state is not allowed to approach the parents with a contract. The parents must seek the state out to take their child if they want it placed into foster care division. For the state to get foster care funding, that's the procedure they must follow. Now, if they want to charge you with a crime to take your child away, the child, there must be a record of the charges either at the local sheriff's department or at the county prosecutor's office. So if you say, well, I was charged with a crime, social services charged me with a crime, so okay, first thing you need to do is call the sheriff's department and say, do you have anything on file about a criminal charge being sworn out against me? And they say, no, I did that, believe me. I said, then I asked to call a county prosecutor. I said, do you have any criminal charges that's been sworn out against me? And they're like, well, no. So then I knew, I was never charged with a crime because that's what they would have to do. So then I realized there must be a contract here somewhere. So for the first 5 or 6 years, what I thought happened was they charged me and my wife with a crime, and they held a trial ex parte without me and my wife being there, and they found us guilty of something. I figured that's what they did. So my first 2 lawsuits you read, I'm saying, well, when you're accused of a crime of neglect and abuse, you have the right to this, you have the right to this. So the first 5, 6, 7 years, all you see me doing is defending myself from a criminal charge. And then when they finally said it was a contract, you see my whole lawsuit flips night and day. I was like, oh, they're saying that there's a contract. Can I see the contract? Oh, that's the contract. Oh, goodness gracious. Holy cow. No. And then I read the Social Security Act. Like I said, it's 672, and Medicaid Act is 472, and it's subsection F. And like I said, it just says that's where you find the state must wait for the parents to say, well, we can't handle our child because, we're poor, and we have no money, so can you please take him away for us before, we do abuse and neglect him because we can't afford to take care of him. But the state can't come after you and say, well, you're not taking care of your kid. So you say, you know what you need to do? You need to have a verified criminal complaint before the sheriff's department or before the county prosecutor before I talk to you. So it's like, and then once you do that, I'm going to move, since that's my property, because oh man, that drove the social service people crazy in 2001 when I said that to them. I said, you want to touch my property without my consent? And they said, well, we don't call children property. I said, well, I do. I said, and that's my wife. She's my property, too. And there were 2 women like, oh, my God, you just called your wife property. I said, what does property mean, man? And they were like, I don't know. I said, whatever I claim is proper to my person, which I believe I have the exclusive right and enjoyment to enjoy. Now, my wife also agrees. She's like, does anybody else have the right to touch you? She's like, no, but I do. Right? I said, oh, yeah, you're my husband. Well, see, there you go. She has no problem being my property, and I have no problem being her property. We have an agreement that I'm proper to her person. She's got the exclusive right to enjoy me. Nobody else can make that claim. Because she'll say, look, I got a marriage license. Look, this shows right here. Right here, he's mine. And I said the same thing with my child. Does anybody else believe that they have a claim to what me and my wife produced through our labor? Does anybody else in this room claim that they have a claim to my property, to my child? So like I said, for years it took us the longest time because everybody that we talked to believed that the state had a right to touch people's children. So Alabama got sued back in 1991 for something similar to this. So what happened was, like, my lawsuit was going to be sealed, and it was Archie. The name is R.C. versus Natchman. And what happened was they sealed the record, so nobody could see how to come after the state of Alabama for the DHR case. So I got lucky, and I tracked down the original attorneys. And I asked the original attorneys, can I please see the lawsuit, how you did it? And for years they wouldn't give it to me. They said, well, no, it's sealed, and, you know, it's still on appeal for 20 years now. I said, come on, guys, you got to give it to me. I said, I bled my heart out to them. I said, okay, fine. So then they asked them, the Attorney General, a very simple question. They said to the Attorney General, I'm trying to get the answer that he gave them. But it was very simple. It says, oh man, I can't find this for the guy. But what the attorney basically said, he said, yes, the state has the right to take, the attorney for the child said, yes, the state has the right to take the children into custody. And, but, you know, there's certain obligations that the state must do once the child gets into custody. The Attorney General for the state says no. The state of Alabama has no right to take any child within its borders into its custody. The only children that we have authority to control are within are the ones that have been adjudicated into our care. So it's like, holy cow. Because like I said, I'd show law professors this thing. I said, does the state have the right to take your child into custody? And they said yes. And I hear so many people saying, well, you got a birth certificate. So birth certificate means the state has the right. It's like, no. If you actually want it, I'm trying to get that. I think it's question number 54 was question number 3 of the lawsuit. And it's like, holy cow. It's like the state can only take a child based upon if it's already been adjudged to be in state control. So it's like, holy cow. Because for years, everybody's lied to. Everybody's like, oh, the state can come in and take your child. No. Only if it's been judged before a court. So everybody's grabbing people's children. It's like, do you have a court order to grab my child? It's like, well, we won't let them come home from school. I said, yeah. I see that. You can let my kid come home from school. That's special, but do you have a court order? And they're like, well, no, we got a complaint. I was like, no, that's not what I want to hear. Where's the order? So that's exactly what I did to the hospital. Where's the order? And they said, well, we just know who Social Services is, and they just told us to take the child into custody. I was like, holy cow. I said, you have no idea what you're doing. You can't just take people's children. And they're like, well, we do it all the time. I was like, holy cow. So like I said, if here it is. This was the question on the RC. This is the answer from them. Here's the exact answer from the state's answer to question number 53 in the RC. No, okay, they changed it to Hornsby, he was the Attorney General at that time. But Natchman was the one in 1997. The answer was, the state of Alabama Department of Human Resources denies responsibility for minors within its borders, but accepts responsibility for children in its custody and care. See, so they're saying they're not responsible for minors within its border. They only accept responsibility for children in its care and custody. And then he went on to explain further that the child had to be judged to be in their custody and care. They can't just say, well, the child's in our custody and care. Because custody means security. Custody is just another word for security. That somebody put up security, and they put up their child as security, that they perform like by the terms and conditions of the contract. So when I read that, I showed that to all kinds of lawyers and law professors, and they were like, holy cow, no, I thought the state had the right to just take the children. Like, no, they don't have the right. The only thing that they're responsible for is the children that are actually in their care. So they have no right to tell you what to do with the kid. And everybody always asks me this question, like, how are you going to get it in front of the jury and get the judge out of the picture? And I gave that to you a while back, where it says, like, Blackstone's commentary, and I always do volume 3, chapter 23, section 378 of the trial by jury. You never say jury trial, you want trial by jury. And it says, but in both these instances, the jury may, if they think proper, take upon themselves to determine at their own hazard the complicated question of fact and law, and without either special verdict or special case may find a verdict absolutely either for the plaintiff or the defendant. So you just say, look, I just want a common law court of record trial. The common law is the law of this land. There is no higher law in this land. I explained that to you folks a while back too. If you actually Google the word land, land means the people. And the common law court is the court of the people. So the land and the people, like I always say to people, you always see that movie in like Excalibur, it's like King Arthur, the king and the land are one. That's true. The king and the land, the king and the people are equal on equal footing, are equal sovereigns. So that law has never been outlawed. So anytime anybody gives me any guff with this stuff, any kind of lawyer, any kind of judge, I just say to them, they say, well, we don't do it like that anymore. I said, okay, can you show me where you wrote down in the law? Because it's ridiculous, even if you do show me a statutory code. Can you just show me where it's outlawed? That a common law court of record is outlawed in this country? So like I said, that's why I made the stylized of my summons different than their summons, because their summons is United States District Court. Now, I'm not summoning them to appear, so if you just fill out, if you just cut copies, if you just use everything that they give you to move your case to the court, the people are going to show up in the United States District Court. I don't want them to show up in the United States District Court. I want them to show up in the Federal District Court. We went down to the clerk of the court yesterday, and there was a man named Tim, and I don't remember the lady's name. And I asked him, I said, what's a court of record? And they said, oh, well, that's where we keep the records. And it's like, okay, you know, under Chorus Juris Secundum, I said, you realize in volume 25, section 344, what does this say? And I showed the man. He said, federal district courts are courts of record. I said, there you go, pretty simple, huh? Yeah, this is court of record. And he was like, okay. I was like, okay, so what's a court of record? I said, well, that's where we keep the records. I said, is there any other way you want to describe this other than just this is where we keep the records? He's like, well, I said, you just do your best. And this was the man who was the supervisor that brought it out. So I said, is it not true that a court of record has the power to fine or imprison for contempt? He's like, look at it. He's like, what? I said, it proceeds under the common law. Not a statute or a code. He's like, looking at me. It's in the tribunals independent of the magistrate. He's like, yeah. I said, well, those are the four elements of the court of record. And sometimes it has the seal, sometimes it doesn't. I said, I got nothing to report. So I said to the man, I said, you don't really know what a court of record is, huh? It moves under the common law. I said, have you ever seen a caption stylized like this? Because if you read my caption, it's like Karl Lentz versus Robert Benton. But the verses is missing. Why did I take the word versus out? Because he's not a defendant. What is he? He's a wrongdoer. So like I said, it just says a man calling Karl Lentz, the aggrieved party prosecutor. And there's a black line between my name and his name. And it just says Robert Benton, Chief Magistrate, Chairman of the DHR, a governor, a public servant, a human, a wrongdoer. So what I'm trying to say is I'm not fighting this man. I'm not fighting the governor. I'm stating a claim that I've been done wrong, and I want compensation. Now, if this man wants to come to court and say that I'm filing a false claim, let him come to court and say I'm filing a false claim. I'm not fighting this man. I'm not bringing a controversy into this court. I'm not bringing a controversy into the public. I'm saying I want compensation because I believe I've been done wrong by these people. Now, if they want to come and answer and say, well, Karl's wrong, I never did anything to him, I have no idea what he's talking about, let them come forward. But it's not plaintiff versus defendant. No, it's just prosecutor versus wrongdoer. I'm just prosecuting, which just means I'm the one who's moving my claim. I'm the one pursuing this matter. But like I said, if they want to, like I said, I just use wrongdoer instead of defendant. I just don't want to make it seem like I'm fighting anybody. But no, I'm not fighting them. Honestly, I hope they don't answer. If you don't answer, then I'm just going to get a nearly decent judgment against you because you failed to tell your attorney what to do. So you can't ever come back and say, well, under the rules, the full judgment says that, since no testimony was taken under open information in open court, I could come back again and I could appeal. And then by that time, all the money I had is spent. It's like, holy cow, here we go. So I don't want to do the full judgment with these people. I just want to do, like I said, nearly decent judgment against these people and get on my day. And I said, and I made my everything you do in the court. I don't do any of this judicial notice nonsense. I don't do any of this. All I do is notice. I just put the thing on the top of it. Notice. I don't notice court. I don't judicial notice. You get rid of all these adjectives and you get rid of all these adverbs. You just make it a simple one word. Notice. So like they say, are you a free man? But no, I'm just a man. All I know is I'm a man. My mom told me I was a man. I believe her. Any other definition of that word, I have no clue where your source came from, and I'm not going to stand here for 11 more years trying to figure out what you mean by free man or sovereign man, and you're not going to diminish my capacity as a man, because as far as I know, the law of this land is the man created the government. The government answers to the man. The man does not answer to the government. And it's like, well, you a citizen, I'm not even going down that path with them. I said, look, what does me being a citizen have to say with they kidnapped my baby? Did you or did you not kidnap my baby? Well, are you a citizen? No. I'm the prosecutor here. I'm the one moving this court. I'm the one who's asking the questions here. Do you have a claim against me? No. Well, then you're moving under my rules. And this is what everybody always gets in trouble with, too. Everybody always plays defendant. But like I say to people, if you're a defendant, you have to move under their rules. So like I say to people, what's a case? Thank God I etymologize and stuff. Case means a casing, like a sausage. You put all the meat and the ingredients in a sausage case. So you're the one who determines what is best for your case. He's like, well, let's put a little bologna, pepperoni, provolone. Let's make a nice case. And you say, well, for this sausage to taste really good, you got to bake it at 350 degrees for 20 minutes. That's the rules. This is how it's going to play. This is how we're going to do it. So when people come in to court and they're the defendant, you're just a piece of their case. So when you try to say, well, I want to do it this way, they're like, no. That's not how the ingredients are mixed, and that's not the rules of how this is going to taste good. No. What you're going to have to do, people, is you're going to have to stop coming in as a defendant because you have to play under their rules. So what you have to do is like say, find out some things that they're missing. Like, is there a verified criminal complaint against me? No, great. So now I'm going to make a claim against you that you're saying a crime was committed or that a wrong was done, but you're not bringing the injured party before the court. So to move court, you have to have the plaintiff. It's an ancient rule. I don't know what it is off the top of my head, but the plaintiff must show up. The defendant doesn't have to show up, but the plaintiff must show up. His attorney could be there, but the plaintiff must be standing next to his attorney. The defendant could just have the attorney show up. The defendant doesn't have to appear. But it's an ancient rule. The plaintiff must show up, because if you're claiming something like an old Bible thing, bearing false witness on your brother, and all of a sudden you're the moving party, and then you don't show up, it's like, wait a second, you wanted us to chop his head off. You file a false claim, so now whatever you wished on your brother is going to come back on you. The plaintiff has to appear. Because if we find you file a false claim, whatever you wanted executed on your brother, whatever you demanded from your brother, we're going to demand it from you. And we might triple it, or we might quadruple it. So you better not be filing a false claim here. So that's what I always tell people. Never come in as a defendant, no matter who charges you with something, unless it's a man. I never help people when it comes to, if you injured your brother, if you injured your neighbor, a man or flesh and blood woman, I say, good luck. You compensate him whatever he wants you to do. If you ain't got money, tell him to come over and rake his leaves, mow his lawn, wash his windows. But you better compensate him somehow, because you done him wrong. But when it's the government, or a county, or a speeding ticket or something, it's like, oh, no, I'm filing a counterclaim against you. Why? Because you're not going to bring any injured party before this court. And since you're saying that somebody's been done wrong, you better have the plaintiff. Because if you're not, you're filing a false claim, and I'm telling you, no plaintiff's going to show up. And I'll compensate the plaintiff now. Right now. You show me who the plaintiff is, I'll give him money. But he's got to put his hand on the Bible and verify that I injured him. Well, the state says the state better put their hand on that Bible and better verify it. Visa or MasterCard, they better put their hand on the Bible and verify it.
That'll never happen.
It'll never happen. So there you go. So you file a claim. Oh, believe me, my sister, it worked with her against Macy's credit card company, and it worked like a champ with her against a she rented out a house, and she just got divorced back in 5 years ago. So this was her first time wearing the big boy pants. So she was always a housewife and always a school teacher. So she moved up here to Virginia by my mom, and she rented out a house. I said, don't sign any contracts until I get there so I could read this for you. And she said, I'm not stupid. I got 2 PhD. I got two master's degree, no PhD. She said, I got 2 master's degree. I know what I'm doing. I said, okay. So as soon as I came to her house, it was a beautiful house, like $1,500 a month to rent it. And I read the contract. It was like 10 pages long. I said, holy cow. I said, let me look. I walked around the house and I read the contract. I said, the minute that you leave this house, if you leave it tomorrow, I'm telling you, the way this contract is written, they're going to charge you between $12,000 and $18,000 worth of damages. And she said, that's ridiculous, just me, my 2 girls, and a dog. I said, I'm telling you, I know exactly what this contract said. So after a year, my sister finally got her own place, and she was getting out of the lease, out of the contract. So that they did a walk through the house, and they said, okay, that looks fine, everything's fine. Oh, there's a little scuff here and a little scuff there, but everything looks okay. So my sister said, well, it's almost Christmas time, and I'm going to need that $1,500 back as soon as you can so I can get my kids Christmas presents. And so, and the lady said, well, we'll see how fast we get the check in the mail. And I was standing right there to my sister. I said, I said to the real estate lady, if you find any damage to this house, would you let my sister make payments to compensate for the damages? She's like, oh, yeah. I said, yeah, so lots of single women who have kids, you offer this to them, too. You let them make off payments. And she said, yeah. And my sister said, oh, don't worry about it. You know, there's nothing wrong with the house. They're going to give me back my money. I said, okay. I said, I just wanted to hear from the lady that she'll make payments with you when she does find something wrong. So funny. Christmas Eve came up. It was Christmas Eve. It was so funny. We were at her new big house, you know, sitting in front of the fireplace. My sister pulls up in a nice little Mustang with her daughter, who goes to some Protestant school. So these are really squeaky clean people. And she's crying her eyeballs out. She says, look what I got from the mail. She says, I owe them $15,000 for damages. So I took a look at it, and I said, this is extortion and fraud. So I just crumpled it up into a fireplace. Thank God she pulled it out. She says, no, Karl, you got to be serious. They're suing for $15,000. They said they're going to immediately seek court action against me. I said, one, they're missing the billing statement. I said, nothing comes out to 0000. I said, Mom was an IRS agent for 30 years. She explained that to you real quickly. Nothing comes out to all zeros. They said, if they're off by 1 penny, that's extortion, because they're asking for a debt to be paid that is not due. Even if it's off by 1 penny, and they make a mistake by 1 penny, you can get them for extortion. And then she said, well, what do you mean by fraud? I said, it's fraud, because there's no way in the world it comes up to $15,000 on a dot. So it's so funny. I said to her, look, stop crying, just have a nice Christmas with your kids, and let me whip out something here in 2-3 sentences for you, okay? I said, by the time Christmas Day comes by, I'll have it all. So she's like, wow, really? I said, yeah, now stop the silly crying. I said, it's just law, it's just a bill, just go have fun. So I made a very simple thing. I just said to the law firm, and it was a great, huge law firm here in Charlottesville, and big wigs, because these people are worth multi-million-dollar companies. She rented from us, PPM, it's a huge rental agency here in Virginia. And they came back with an itemized statement of the bill. And it was like $8,749.13. I was like, there you go. There's proof of extortion and fraud. So I sent them a letter. I should pull it off the computer real quick. But I basically was just saying, thank you for your timely response. Now, under Virginia Code, blah, 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 you committed extortion. Under Virginia Code, blah, 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 you committed fraud. Because the first bill you sent said $15,000. The second bill you said has $8,000. So that's absolute proof beyond extortion and fraud. Anytime you'd like to bring this matter before any court in this Virginia, we'd be more than glad to take this before a common law court of record here in Virginia in front of the jury. We'll show our exhibits, what we have, and we're going to file a cross-claim or a counterclaim against you for $60,000. So if there's any more correspondence that you'd like between us, you just let us know. And my sister never heard again from them for the next 4 or 5 years it's been. So my mom taught me that with the IRS, because I loved her shift. I lived right up the road from him in Vegas. And my mom worked for the IRS. And my mom was an IRS auditor since 1972, so I basically grew up with an IRS agent living in my house as my mother. So I asked her some simple questions in 1987. She did my taxes for me, and she said to me, how do you owe money? You only make like $5 an hour. You know, it was like 1987, you know. It's like working in a bowling alley. She said, how do you owe money? I said, well, I put down like 10 exemptions. And she says, holy cow. She said, that's fraud. She said, you go to jail. I said, well, what should I do? She said, just do this. And then she gave me a W-10 form. She said, just write exempt. She said, put 0 with every box, cross out the 0, and she said, the very last line, write the word exempt, and highlight it. And she said, that way they won't take any more taxes from you. And that way you're not held liable. I said, you're kidding me, it's that simple? She said, yeah, it's that simple. I said, I don't have to be like a college student. She said, that's ridiculous. She said, and she opened up the IRS, like the 1040 book. She's like, welcome to the IRS, welcome to the 1040 form. This is a voluntary compliance system. She opened the very first cover. She said, what does that first sentence say? I said, voluntary compliance. She said, yeah, you want to volunteer? I said, well, hell no. She said, well, take my word on it. You zero down the board, write exempt. I said, wow, that's simple, that's simple. She said, you'll never owe another dime. So I haven't done, and like, I don't care what IRS agent is listening right now. You can check my, I'll give you a social security number if you ask Angela for it. I'll give you my social security number. And I have not done an IRS return since 1988 because I've been exempt. And somebody in Las Vegas, when I was doing some fiber optic work, I hooked up with a contracting company. I was telling you earlier, Cox Cable. They took out my taxes like 3 weeks in a row. It was like $200 a week they were taking out. And I was like, because I was making like $2,000, $3,000 a week. So they took out like $200 in IRS tax. I said, whoa, where's my money? They said, well, the billing company that we do all the paychecks, automatically, if you don't, they take out the maximum deductions. They take out like one deduction if you don't put anything down. I said, I wrote 0 and exempt. So they said, well, and I called them up, the billing company. They said, well, we're not going to do that. You will pay your taxes like everybody else. I said, oh, you think? So I drove from Phoenix up to Vegas, and I said, and I went to the receptionist lady. I said, who's the man in charge here, or the woman in charge here? I said, what do you mean? I said, look at my paychecks. You see this? And they're like, yeah, I have taxes taken out. She said, well, everybody pays taxes. I said, ma'am, who's in charge here? And then she called up the guy in the back, and I said to the guy, I said, why are you taking taxes out? Well, everybody pays taxes. I said, sir, I keep the, this is what I do. My mom taught me that too. With the W-10 form, the W-2 form that you fill out when you work, when you start working, you keep the original copy. You write across the face of it, copy, so that way they know you have the original. So you give your boss a copy of the W-2. You keep the original. So that way when anybody tries to take taxes out on you, you say, wait a second, here's the original W-2 that I submitted to my company when I started working here. It says exempt. Where's my money? So what was funny is the guy said, well, you know, we're going to inform the IRS of what you're doing. I said, hang on a second. Let me get you a business card real quick. So I whipped that up. He says, oh, Pat Garner, Holtzville IRS branch, federal agent, tax auditor. I said, yeah. I said, do you want to give that call real quick? I said, I know she's still working. East Coast time. I said, she'll still be there. He says, I said, yeah, she's an auditor. She's got the highest security clearance than you would possibly imagine. I said, she's one of the best tax collectors that this country's ever seen. So give her a call. I said, and when you call us, say to her, hey, your son Karl hasn't talked to you in quite a while. He wants to say hi. I said, so if you want to ask my mom, can Karl be exempt? She'll tell you. You're damn right he am. He could be exempt. I said, now, we got one or two choices here, buddy. You're either going to put that money back on my paycheck next week, or I'm going to get the sheriff down here. And you stole my money without my consent. And I clearly told you, you're not taking my money. So now you will either give me my money, my next paycheck, or I'll get the sheriff down here. He says, you'll get your next paycheck. I said, you're damn right. So the next week, you got my paycheck. I had an extra $600 in there. Everybody said, wow, it worked. I said, of course it works. It's the law. Everything's based on consent. So if you don't consent, there you go. And you don't have to talk to anybody, because me and my mom used to go around and around. She said, well, who's going to pay for the hospitals, the roads, and the bridges? I said, look, that's fuel tax, that's all this other. Don't give me this nonsense. Don't give me this nonsense. I said, is there anywhere in the law that says the government can compel me or force me to put a pen in my hand and turn witness against myself? I said, show me the law that says I must take a piece of paper and a pen and I must write things. And she said, well, yeah, that doesn't, because my mom let me bounce things off of her like crazy. So she was great like that. And I said to my mom, I said, oh, okay, so now when you call people in to audit you, because my mom was gorgeous back then, she looked like Crystal Gale. She had really long black hair, blue eyes. She looked like Elizabeth Taylor. She was gorgeous. So everybody would come in, and she'd play good cop, bad cop. And she'd say, look, if you don't work a deal with me, I got a supervisor next door, Bubba, and he's in a really bad mood today. So you better let me just do your taxes, and we better work on an agreement here somehow, or you're going to jail, or you're going to go talk to Bubba. So I said to my mom, like, wow, that's pretty cold, you know, what you do to people. And it's like, you know, that's not right. She said, well, who's going to pay for that? I said, Mom, stop that. I said, Mom, if I came to you and I said to you, fill out my taxes for me, now sign it, and say that's what I owe. She said, I can't sign it. I said, yeah, I know. I heard like an orange shift guy say that you can go to the IRS and say, why don't you do my taxes for me? And now, lady who's doing my taxes, now sign it and say, I owe the IRS this much money. She said, that's impossible. We can't sign it. We could already tell you what you owe, and you got to believe that's what you owe.
There's someone on the chat that's asking, why are you not charged like everyone else for failure to file a 1040?
Because I did file. I did file a W-2. When I started work, I filed a W-2. The W-2 said I was exempt from filing. So there you go. What do you mean charged? Did they not?
That's their question. Okay, but let's get back to, you know, we unmuted Granny way back before we started the call, an hour ago. And you were going to have a little conversation with Granny. She's been waiting patiently. You still awake, Granny?
Yeah, I'm here. I'm listening.
Did you have any questions for Karl regarding custody issues?
No. It's all very interesting, and one will have to listen to this call a couple of times to take it all in. But
Miss Granny, did you get an email from me?
I've seen an email written to someone else.
Okay, yeah, and then he said he was going to forward it to you.
Yeah, right.
Your granddaughter got taken was placed with a police officer?
Well, he's a, kind of a what do you call it, an extra city policeman. And then he has a daughter who is a state trooper.
Okay. I just wanted to make sure that when we talk to I was talking to the right granny here, because I think I made it very simple what I said you should do. I said all you do is you give notice. Don't make no fancy words, just say notice. You give notice to the party holding your child that they are in naked possession of the child. Okay? This very simple.
But you're talking about the government, the court. Did your child get adopted?
No, they were trying to adopt them. Oh, believe me, they adopt them out like crazy.
Okay, my granddaughter has been adopted. She's been adopted now for several years.
This will work perfect. Because like if you know where she is, it really helps because you give notice to the person holding that child. You just say, I'm giving you, Bob Johnson, notice that you're holding my granddaughter in naked possession. If he doesn't know what naked possession means, that means you have no legal lawful claim to this child. There's a difference between, like I said, a court giving somebody something, and that'd be legal, a legal decision, or lawful. Lawful means, simple things. Law means, no injury, no harm, or no damage to a man. So naked possession means they're holding the child without a lawful right to do so. They might have a legal decision. There might be somewhere legally it says they can, but it's not lawful. So like I said, first thing you do is you just give a notice to the person, make it one sentence. You are in naked possession of my granddaughter. And then what do you say after that? You just say, you declare to them that it's wrong to hold my child in the manner that you're holding her. And then you just say, my baby was stolen from me. And then you just say, as no man has come, and then you just say, my baby's been stolen from me. And then how I wrote to you, I just said, as no man, and then this is how else you can write, as no man has ever come forth at any time before a court of record and claimed they had a superior claim to the possession of my infant. Now I'm moving my claim. And for the immediate lawful return of the possession of my child is to be placed under my control, and I'll bring you forth before a court of record to verify my claim. So it's fairly simple. You just basically telling the people, whoever's holding your property, I don't care if it's a car, I don't care if it's a yo-yo, I don't care if it's a child, you give them a notice. You just say, look, you have my child, you have my yo-yo, and I want it returned. Maybe you didn't realize it was mine, but it's mine. Even though you might have got it through some sort of legal process, no man has ever come forth into a common law court of record and verified under oath of affirmation that they had the right to possess my child. But I will do that because the highest court in this land is a court of record, and this country moves under the common law. And I sent that to Angela last week, the federal website that said all state courts are common law courts. So when I hear these people arguing me all the time about administrative courts, equity, and all this other nonsense, it's like, well, it says right at the federal website. If you turn to page 1 of the federal.org, federalcourt.org website, gov, it says all state courts are common law courts. So where can I get my child returned to me? Through a common law court. And the common law is, if Granny says that's her baby, the other man is going to have to come forth, and now he's going to have to claim that that's his baby, that he has more right. So then you just move before a jury. You get that judge totally out of the picture. So like I said, this is the nonsense that I had to deal with. Believe me, I know the nonsense. I went through 9 judges through the administrative process, the same exact way you're going through. And you're saying, well, this is the government. You put the government back where they belong. You put them just as a referee before a common law court of record. They're just going to be recording what happened at that trial before a common law court.
Yes, because I know they're supposed to just be a referee, but they're not. That's not what they do.
Well, that's what the way I'm doing it is way too simple. All you do is give notice to the other side that if they don't return your child, you're going to charge them $1 for every second that they're holding naked possession of your child. Unlawful.
Does that come close to Tresevant versus Tampa?
I don't really do like those cases like that. But a good one you could use is Anonymous versus Anonymous. That's 1995 out of Alabama, or Stone versus Wall, 1996 out of Florida, and that went to the appellate court of 11th Circuit down there in the South, and that's what got compensated for somebody illegally taking their child. Yeah, and they lost in the lower courts, like we're good, but when they made it up to the 11th Circuit Court of Federal Appeals, the parents won. So you're dealing with administrative courts. This is the whole problem with everybody. Everybody's dealing with administrative courts. You've got to just say, look, administrative court is on the right-hand side, common law is on the left-hand side. Is there a reason why, Judge, we can't move this into a common law proceeding for me to give you an answer? I can't answer you here under the codes. I don't read codes. I'm an idiot. I don't speak legalese. Is there a reason why I can't have a common law trial and a trial by jury under the 7th Amendment? Or you just say, or the 9th Amendment? You just say, well, it's really not an amendment. It's the Bill of Rights, the United States Constitution, Article 7 and Article 9. Honestly, the First Amendment is the 11th. The ones, what you call First Amendment, Second Amendment, Third Amendment, Fourth Amendment, Fifth Amendment, is really the Bill of Rights of the United States Constitution, Article 1, Article 2, Article 3. See, so a judge would pick up on that. The judge would say, oh, you're using your Second Amendment rights. Oh, that's so funny. There's no such thing as a Second Amendment. It's the Bill of Rights, the United States Constitution, Article 2. There's no such thing as Second Amendment. So I got a Second Amendment right to hold a gun. Yeah. Sure you do. You have no idea what you're talking about, buddy. Next case. So see, the judges will pick up real quick if you actually know the words that you're using, and that's why, to me, it's so important that you just make it very simple. Everything has got to be 1 or 2 sentences, and just get on. Because you guys are putting hundreds and hundreds and hundreds of pages before these courts, and this is ridiculous. Is there any man who's going to verify under open affirmation, open court, that they have a superior claim to title of that is that child? I know no man is going to come forth and claim that they have a superior claim to that child. That child is the property of my family. That yo-yo is my family's property. We built that chair. We grew the tree. We cut the tree down. We could show you when the chair was half built. We painted that chair. Out of our labor, we produced that chair. That's our issues. You can't take our issues. You can't take our property. We never consented. Can somebody show us where we consented to turn that chair over to anybody? Oh, did they ask you to sign a contract, or did they ask your daughter to sign a contract to put the child into the state's custody, like a safety plan or something?
They asked my daughter to sign away her rights. She told them to drop dead.
Okay, so how did they put the child into custody? Was she found criminally guilty of something?
No. She was ill. No, they did not charge her with any criminal. And this is one of the things that our organization here in the state is trying to get the legislature to change. You can't. No child should leave a parent unless there's a criminal complaint and conviction. They may take the child and move them to a relative if they fear, that the child would not be safe. But you don't snatch a kid.
Well, there's only 2 ways you can take a kid. There has to be a verified criminal complaint on record with the Sheriff's Department or with the County Prosecuting's Office. And if you're saying there is no criminal complaint, the only other way they could have done it was based upon a contract. She had to sign something.
Well, she probably signed a parenting plan, which is something that is always done with the contracted agency of CPS. They always get you to sign this plan. Well, you're going to go to this class, that class, et cetera, et cetera. She probably signed that because everybody is stupid at that point of the game and signs.
Yeah, well, that's the only good thing about me is that I never signed, and they just kept telling me if we just signed that plan, that the child would be returned immediately. And I said to the judge says, are you crazy? All you have to do is sign a piece of paper. And I said, look, I don't make a deal with the devil. I said, there's some way you're going to screw me in this deal, so I don't sign anything. They said, look, it'll be all over. You'll have your child back. You don't have to come here no more. I've went to trial 30 times. But like I said, ma'am, it's very simple. In Alabama, it's under the 660 administrative codes. It's like 660-5-17B. It says if the parent parent signed a contract, a safety plan, like a parenting class thing, with the state, all the parent has to do is come before the court and wish. The actual word is wish, and wish to have the child, and the child must be returned immediately. I mean, I'll actually send Angela that actual code, and it sounds almost ridiculous that the courts and the states actually use the word wish. But it's that simple. Your daughter just never went to court and say, I wish for the immediate return of my child. She's done everything else. She's got attorneys. She's filed all kinds of briefs and paperwork and hundreds of pages of nonsense, when all she had to do was go to court and make a wish.
That's what Bill Thornton says. He says, you know, if you make an objection in your case, and the judge says on what grounds, all you have to come back with is it's my wish.
Right, and I really studied that word. I actually found it in a lot of administrative codes, a lot of statutory codes, that if a man makes a wish, it must happen immediately, because you're putting the government in their spot, that they're your public servant. You are the master. You are the public. They serve you. So is that your wish? Watch, like I said, some of these YouTube videos, and you'll watch the judge ladies say to the people, you wish to be sentenced today. And people are stupid. And they say, well, or do you want to come back and spend another 6 hours in court? It's like, okay, fine. You're consenting to let them run you over like a freight train. And then they can do whatever they want, because it's like, oh, okay, I'm the genie. I get to make you made your wish. Okay, here you go. It's like, yeah, okay, well, I wish to go home. And it's like, well, you know, that's not an option today. It's like, well, who's claiming that, you know, I can't take my child home today? Who's got a superior claim to this child other than me? The state can't claim the child. It's not their property. It's like, oh, show me where you produced this child. Was that the fruit of your labor? Did you build that chair? No. Then who gives you the right to take my chair? That's private property. You can't interfere with my right to property. That's a huge constitutional protection, that the state can't interfere with your right to your property. And if they do take your property, you could sue them for interfering with your rights to the property without just compensation. That's like I said. If you read the Alabama Constitution, it says that the state of Alabama cannot be made liable for a suit at law at any time. I mean, and it said, and it's so funny. In 1996, it says the Alabama Supreme Court said, well, you can sue the state of Alabama if your property was taken without just compensation. Yes, Section 14 of Alabama's Constitution, state not to be made defendant. That the state of Alabama shall never be made a defendant in any court of law or equity. In 1996, it said, no, the state of Alabama can be made a defendant in any court of equity if man's property was taken without just compensation. So you say to the state of wherever you live, okay, you took my property. Did you just give me just and fair compensation? I claim my child is worth $1 million. Did you give me $1 million yet? Well, no. Well, now I'm making my claim for the compensation. You took my property, right? Okay, that was my property. Okay, you know what I forgot to do? I forgot to give you a bill. I just let you take my property. Oh, did you think it was free? Oh, no. Here's your bill. Here's a bill for $1 million. And like I said, the bill process is simple. You know, just like I'm doing. I'm giving them a bill for $300 million, for $300-something million. I'm giving them a bill. I'm saying within 21 days, if you don't answer, you think this is a joke. All I'm going to do is ask for the clerk of the court at the federal court to stamp the seal of the court on it. She'll do it. And then if you watch TV at 2, 3, 4, 5 o'clock in the morning, it says, we buy judgments. We'll buy any judgment. If you hard up for money, you got $1 million lawsuit that you want, you need cash quick, we'll come and buy your judgment. So there you go. I'll have a judgment. I will sell that judgment in 20 seconds. As soon as that clerk of the court stamps that seal, if you know what the holder of the due course rule means, they're going to have to go after the guy who I just gave that $300 million judgment to. So the guy with the $300 million gives me $3 million. I don't care. I took the money, and now I'm in Tahiti somewhere. And the governor wants to appeal it. It's like, well, we're going to appeal it. This is ridiculous. It's like, okay, where's the judgment? I sold the judgment. Oh, who's got the judgment? I don't know. Some Chico Bear Bond in Florida bought it for me online for $3 million. Go sue him. And Chico Bear Bonds say, I'm the holder of due course. No, you can't sue me. I bought this fair and square on the open market. This is mine. Karl had the judgment. Karl sold it to me. It was Karl's judgment. Karl could do whatever he wants with his property. That judgment was Karl's property. The judge sealed it. It was good enough for us. Karl proved it was his property. The federal court said, yep, that's Karl's property. It's Karl's judgment. Karl got awarded the property. I don't have to keep that judgment for a day or 2 days or 72 hours. I'm going to go online in 10 seconds. As soon as I put this lawsuit stuff in, I'm going to find out who's would be willing to buy this, who'd be willing to give me the best offer. Then I want to take the money and say, yeah, I'm going to Tahiti. Have a nice time. You'll say, hey, wait, we're going to appeal this judgment. Yeah, go ahead and appeal it. I don't care. Go buy from Chico's bail bonds. He's the one who's holding the judgment now. I don't know how you're going to get it back from him. I guess you go give him $3 million and he might buy it back from you. But he could turn around, he could sell it. He could have sold it 10 more times. It could be sitting in Hong Kong right now, for all I know. Why the hell do I care? So like I said, you could watch something on YouTube videos. It's Holder and Due Course Rule. It's very simple. It's a 2-minute video, 3-minute video. Very, very simple. Watch the cartoon one with the guy in a boat. Very, very funny. Very simple to understand.
Holder and Due Course is called?
Yeah, Holder and Due Course Rule. It's a song. It's actually some law students put together with their law professor a song called the Holder and Due Course Rule. It's incredibly entertaining. It's really funny. It explains exactly what I said. You take that judgment and you sell it immediately. You get rid of that thing. You don't sit on it and say, well, now what do I do? Now I got a judgment for $1 million. Now what do I do? Sell it. I mean, get rid of it. You have 21 days thinking that you're going to get the stamp from the clerk of the court, right? Because the other side's going to fail an answer, right? Yeah. So get the damn stamp from the clerk of the court. Say, did anybody give an answer? No, good. Stamp that damn thing for me. Give me a judgment. Yay. Boom. I'll go sell it. Like I said, if you watch TV at 2, 3 in the morning, you see it all the time. Does anybody need money fast because your leg got run over by the school bus and you need
Here's one that's called the Holder and Due Course Blues.
That's it.
Okay.
So much it's scary.
I'm going to put the link in the chat so everyone can look at it later.
Yeah, a whole bunch of students wrote that. It's not some clown like me. This is a law professor. Most students actually did this for a project for a school, and it's incredibly simple to understand. You're like, holy cow, so the whole trick, and this is what I told the state of Alabama. It was
Do you ever stop and take a breath?
I'm from New York, so...
You have been talking non-stop for 1 hour and 27 minutes.
Wow.
But Angela, this is wonderful.
Yeah, well, he's all over the place, too. Did you have anything you'd like to ask him?
Yeah. Hey, so which is better to do, or do you do both? The wish and the naked possession, or?
That's what you could do when you notice. You could say, you just right across the head of things, and then they notice. And then said, Officer Bob, it is my wish to have my granddaughter returned to me immediately. I believe that you are holding my child in naked possession. And until that child is returned to me, I'm going to charge you $1 for every second until my property. You call it property. You got to call it property. Don't be shy, because women are...
Well, wait a minute. She's the grandmother. Is that the same?
Yeah, I was just going to say that. Do I have the right to do it, or does my daughter need to do it?
You could do it, because it's from the family Johnson. It's from the family Granny. You have more claim of that child than that man certainly does in front of a jury.
See, I had my grandchild anyway. My daughter had given me my grandchild to care and custody of my grandchild, okay? So the state had to, in order to terminate my daughter's rights, they had to take my granddaughter from me. And that was wrong, because that took away their subject matter jurisdiction. They had no right to do that.
Well, your rights can never be taken away. What they did is they took away her civil rights. See, civil rights are not rights. Your rights can never be surrendered, revoked, or abandoned. You never lose your rights. What she lost was her civil rights. Civil rights is what the state gives you, grants you. And if you don't know the difference between her rights and her civil rights and her rights, you guys got to stop adding adjectives and adverbs in front of your names, in front of your words like that. It's just, you have a right to that grandbaby. It's your grandbaby. Is anybody going to stand in front of 12 people of a jury, like a whole bunch of, like, say, little old ladies who watch Oprah all day, who's going to sit in that jury box? Is anybody going to sit there with a straight face and try to claim that their claim to your grandbaby is superior than your claim? And that's all you got to do in a common law court of record, in a civil matter like that. It's a scale of justice. It's just got to tip just one little inch towards your side. You just got to win by 51%. So if you get 7 out of the 12 people to agree that no, Grandma should have that baby because that's from Granny's property. That came from Granny. That's Granny's property. Let that Mr. Policeman Bob try to prove that property came from his fruit of his labor. You had the daughter had the grandbaby. It's just that simple. It's all property rights. That's all you're trying to do. You're trying to drag them into court and say, that's my property. And because when I say to people, what's the more superior word, rights or property? The more superior word is property. Your rights are what you claim is proper to your person. So your rights are your property. So if they say, well, I got rights. Well, you know what? You better start using the word property, because they're trying to make all women and men embarrassed by saying, well, my wife is my property, my child is my property. They're trying to get you people embarrassed to say that word, because they know it's actually superior than saying that I have the right to my wife, or I got the right to that child. No, that child is my property. Is anybody going to make a claim that property is not mine? Well, they have a superior claim to that property than me. And no man is going to stand in court and actually say that with a straight face, and the jury's just going to laugh at him. So what you could do, you could do it both ways. You could tell your daughter to say, look, my property was taken unlawfully, not illegally. They got all kinds of codes to back up what they did to her. Just say unlawfully. My child was taken from me unlawfully. My property was taken from me unlawfully. And if you want to take my property, I want $1 billion for that baby. You know, do you want to pay me $1 billion? And even if you still pay me the $1 billion, I still want something else. I still want to be able to visit her 24 hours a day, 7 days a week, whatever. But like I said, you just had to make them understand that that's your property, and they had no right to touch your property without your consent. Even though she signed all this nonsense with the safety classes, the pairing classes, I know exactly what she signed, because that's what they tried to get me to sign. And I said, no, I'm not signing any of that nonsense. We're not doing any of this nonsense. You're not touching my property without my consent. And I said, and even if like I said, if they proposed an offer to her, if you read the Social Security Act 672, the Medicaid Act 472, subsection F, you will see where it clearly says that the state cannot tender a contract to the parents. The parents must seek the state out. The state has no right to make you an offer. Let's put it this way. They can't go door to door and knock on your door and say, hey, would you like to give me your kid today? What do you mean? Well, we got an offer. You see, here's the contract. Would you like us to take custody of your child? No, thank you. Okay, we're going to go next door and knock on that door. They can't go door to door. They can't make the offer to you. You got to go to them. See, and most people don't understand that. It's like, no, they can't make the proposal. The government can't make you an offer. They can't do it. So let me see. I'm just going to hit 672 real quick. Yeah, it's the Medicaid Act 672. And it's the Social Security Act 472, subsection F. And you'll just read that one sentence and say, holy Christmas. Yeah, the state cannot make an offer to place the child into the state's custody. They can't make any proposal, any contract offer to the parent. The parent must seek the state out and say, we need help. So, like I said, people just don't know the simple rules. That the government can't make you an offer. You got to come to them and say, hey, can you help me? Your job is to serve me. You're my public servant. I'm having a problem with my kid. Can you please help me?
We have a couple of people in line waiting to ask you questions.
Okay, yeah, go ahead.
You want to take a couple of
Angela?
questions? Yes, Granny?
Okay, I'd like to understand one other thing. I'm a little
Go right ahead.
confused here. If you do the wish in the court, is that a court case or is that like a motion?
Great point, because everybody always forgets this. Okay, sorry about that. I should have told you guys this. Because the judge warned me of this. He says, Karl, you've got to let this case die. I was like, I don't understand. They took my kid. It's called JU 2001 51832. This is the case. He said, stop filing damn papers under this case. It's not your case. I was like, what? It's the state's case. They put you in it. You're the ingredient. You can't modify or change their case. Oh, that's a great question you asked me. You've got to go to court, and you've got to make a claim with the court, and you've got to generate they will give you a new case number. That's a great point. I'm glad you brought that up. See, that's good that somebody asked me a question. So you go to court. I don't care, you go to your local district court, or you go to local circuit court. I don't know if you could ask the lady, the clerk of the court in district court, ask her, is this a court of record, like a Nisi Prius court, or is this the court of record, a full court of record? She'll probably tell you, no, you got to go over to the circuit court. If I was you,
Probably would do this with the circuit court, and then when it comes to the damages, either go to the federal district court or go to the state court of claims.
Well, don't go to anything with a fancy name like Court of Claims. What you would do is, what I would do is, I would go to a federal district court. Like I said, the way I sent the stuff to Angela, you just copy and paste what I did, and that'd be fine. When you're asking for compensation for somebody taking your property without your consent, that's exactly what I'm doing over a child. You can just follow that. But the big thing is like I say to people, I don't care if it's a traffic ticket, I don't care if it's a child case. Whenever they try to drag you into their case, their casing, into their sausage, you're just an ingredient that's going to be chewed up. What you've got to do is like, oh, I got a case against me. Oh, JU 2001. Oh, good. Well, you know what? I'm going to go down to my district court, or I want to go on a jury trial. So they say, well, we don't do jury trials here in district court. You got to go to circuit court. Great. I'm going to go right over to circuit court and say, look, I believe somebody took my property without my consent. They said, well, you know, it's got to be over $10,000 in value. $10,000 is believe me, my property means worth $1 billion. Yeah, I got a claim. So like, oh, so then you make the claim there, and they will give you a case number. So what will happen is you'll go to family court. This is going to be sweet. You go to family court, and the family judge lady will be saying to you, okay, you're here to answer case JU 2001, da-da-da-da-da-da. They say, yeah, while we're at it, did you get my case that I got against these people in circuit court? They say, what case? This case. Didn't you see it before you? And they'll be like, what? They say, let me take a look at that. It's like, oh, you're suing the DHR, CPS, for $1 million for taking your property without your consent in circuit court. But yes, do you want to hear both matters here today? Or do you want to just meet up in circuit court? And we'll have it held over there before the jury. Because whatever you rule today is basically irrelevant, because we're just moving under statutes. We're just moving under our code. And common law court of record is superior to you. So whatever administrative ruling you make today, it's just a rule. It's just a decision. It's like I say to people, when you make a rule, like I said, without the Supreme Court of the United States, they just make rules. So if you guys are looking at an opinion from the Supreme Court of the United States, they don't make orders. They don't make law. They make it's the decision of the court, or the rule of the court, or the opinion of the court. It's just an opinion. They have no power to enforce their opinion. They have no marshal service that says, well, carry it out. They just make a rule of opinion, like tell people what happens if you're making the rules today, and you say, well, we're going to play baseball, but now we're going to run third base, second base, first base. We're going to run backwards. It's just a rule. It's not a law. It's just a rule. So that's why you want to drag them over to a trial by jury, court of record, under the common law. You want to get a case going, and you want to drag DHR into your sources, into your case, and let them try to stand there in front of the jury and explain to them why they believe that they have the right to take your property. So sometimes it's good to have the jury trial like that, but you might have 12 little ladies that say, well, you know, maybe the state should take over your child. So sometimes it's actually better to just go have a bench trial in a common law court of record, because you just show the judge the law, and the judge has to say, well, gee, that's the law. You know, she's got the property. No man has come forth to claim that they have a right to that property. DHR's not a man. They can't claim that property. They can't verify stick their hand on a Bible. Because like I said, I've seen a Judge Judy episode, and I don't really like Judge Judy. But it was like 5 minutes to 4. Like, and then I heard the music start. I was like, wait a second. They don't have, like, continuation of her show. So what's going on here? How's she going to do a case in under 5 minutes? So it was funny. It was here comes the complaining party, the plaintiff. Catholic church ladies, a school bus full of orphans got hit. The front bumper got hit and got knocked off by the defendant, the black guy. And he's claiming that he has no idea what the hell they're talking about. So Judge Judy says to the Catholic ladies and the school bus driver, say, go ahead, tell us what happened. It's like, well, we were going, you know, to a daycare with all these kids, and this guy ran a stoplight. And
what are we doing, Karl?
Just watch this. This is what I'm trying to explain. This is great. Watch this. What happened was, this is going to explain really good. I'm telling you. What happened was, Judge Judy said to the plaintiffs, go ahead, tell your story. So this black guy came through the stop sign, knocked him, but he didn't have a driver's license, so we didn't call the cops, and he said he'd settle this on a private side because his brother owned a junkyard. So when we went to the junkyard on Saturday, nobody was there. We knew who this guy was. So then the lady's like, okay, black guy, go ahead. Now you tell us your side of the story. I have no idea what these white crackers are talking about. These ladies are crazy. I don't know them a damn dime, and I want to get the hell out of here. Judge Judy said, case dismissed. And I was like, what? What do you mean? This bus is for the nuns and kids, and they want to testify. And the nuns said that. They said, what? We got all these pictures and photos. And she said, ma'am, this is what happened down south years ago. A white lady would say a black guy touched her. All of a sudden, all the white women in the community were going to hang this guy, and a black guy like him would be hanged. So she said, in standing in court, the black man is just as equal standing in court, no matter how many hundreds of white people that you say that he did you wrong. They used to lynch black people like this in the South. So sometimes you don't want a jury trial because you get a whole bunch of 12 little old ladies who fight for the nuns who got their bumper knocked off the bus. But since the black guy was smart, Judge Judy said that. She said, I read this guy's criminal rap sheet. He's been in prison his whole life. You know where he learned the law? He learned the law in prison. He knows exactly what to say. He has no idea who you are. He never seen any of you crazy people. And she says, I know he's lying. But the law says that he has equal standing in court. The scale of justice cannot be tipped one way or the other. So she said, case dismissed. And I was like, holy cow, Judge Judy, I can't stand her, but boy, did she just teach me something that I'll never forget. I don't care how many witnesses the other side has. I don't care what exhibits they have. If you stand your ground and you say, I'm telling you the truth, you've got to convince the judge, and it's not going to happen. But can they convince the jury? Yep, that black guy would have lost in front of a jury. If he said, well, I'm a defendant and I want a jury trial, well, you would have had a whole bunch of little old ladies that would have thrown the book at him. So sometimes you want to go before the judge, because no matter how many witnesses or like I said, you always
so you mean you want to waive your right to a jury trial?
Sometimes, because like I said, when you see movies, like a gangster movie, where they're trying to hide Joe Pesci as the federal prosecutor, the federal witness, see, they're in the federal witness protection program, they know that if Joe Pesci doesn't show up and point the finger and say, John Gotti told me to do that, they have no case. Even though the FBI's got videotapes, surveillance tapes, audio tapes, records, bookkeeping records, they got all kinds of, they still need a man to stand in court, stick their hand on the Bible, and point at John Gotti and say, he told me to do it. And that's why you see all these witness protection movies. Because it's funny, you know, the Joe Pesci, they're running them all around town, all around the city, and everybody's trying to kill them, because they know the law. The judge knows that they can't do anything without a witness pointing the finger and saying, I saw that man do it. Somebody's got to verify in open court and after that information saying that they did it. And then they could use all that exhibits behind it. But like I said, when I saw Judge Judy do it, I was like, holy cow, that's like the Joe Pesci movie. You just keep, until something can come forth, there's just equal standing. You need somebody to come forth. And so the poor people, the poor bus people, they did not have a third-party impartial witness. They should have just said, well, this black guy saw it. It's like, oh, the black guy saw it? Yeah. Come forth. Sir, do you know anybody in this party? No. Do you know the black guy? No. Do you know these nuns? No. I have no idea what you're talking about. I've never met any of these people. Tell us what happened. Well, then he's a third-party impartial witness. Now he can testify. And now the judge will hold the scale of justice towards the nuns. He's like, okay, you brought a third-party impartial witness for. Now we can actually have it. Now we actually have a case going on. Until then, you can't bring any third-party impartial witness and say, I saw him do it.
Okay, so in Granny's case, how does this relate to what she just asked you, the question?
I'm saying is that's why sometimes you just want to go before a judge. And you don't want to go before a jury because say his daughter was on crack or PCP or angel dust or whatever. And then you'll have a whole bunch of people in the jury think that it was warranted for the state to jump in and intervene.
Right.
And sometimes it's like, well, show me the law where it says the state can do that. There is no law. If the state has any right to any possession of any, like I read to you folks about the state of Alabama, question 53, when the judge, when the state was asked that question, and they said, no, we do not have, we are not responsible. It says right here, the state of Alabama, Department of Human Resources denies responsibility for any minor child within its border, but accepts responsibility once the child is in its care and custody. So see, that's the law. They have no responsibility for the children within their border. But once the child has been placed in their care and custody through a court process, then they're responsible for the child. But until then, they're not taking responsibility for all the children out here.
Then how do they take the child before they adjudicate?
Because they don't know the law. People just believe. I believed it. I believe they had the right to take the child and say that we did something wrong. And so I actually read, this is why they buried this line from the judge. It's like I said, if you listen to the state over and over, I don't know if you ever found this online, but this was the state's answer to question number 53. And it just, the man sent me the lawsuit, and he had like 100 questions, like 100 statements on the lawsuit. And this was statement number 53. It's like, yes, the state is responsible for the children within this border. We understand that. But even though they have the responsibility, there's certain duties and obligations they must do. And the state says, no, we have no responsibility for any minor child within our border. But we accept responsibilities for the children that was placed into our custody. So that's the whole.
I can see that a jury trial is something that could possibly get you into trouble just by going on and on and on.
Right.
And that what you're saying is, if you go for a bench trial, it's pretty cut and dried.
That's right. They can only do what the law says they can do. And what the whole trick is, you just say to them, where do I appear under that code? Where did I consent to this, to accept this? What happens if all of a sudden they make some crazy law tomorrow that says no grandmas have any rights to their grandchildren? They can make a law like that. It's like, so when did I comply to when did I accept this code as my code? Because Dean Clifford makes a great statement like that. He's saying that any time you want to, you could say, I'm exercising my right to be a citizen, but now I'm exercising my right to just be a man. I don't have to be a citizen 100% of the time of my life, because I give people a great example. What happened if we're on Al Jazeera Airlines and some PLO Palestinians take over the airline, and I'm sitting in coach, and they come in and say, all American citizens come forward so we can rip your throats out and throw you out of the plane. Am I going to say I'm a U.S. citizen? No, of course not. So I'm going to, so just because the judge says you're a U.S. citizen, you say, what? So you can rip my throat out? I'm not going to say anything. Well, what's the meaning of the question? I don't understand where you're coming from with this. All I know, I'm talking about I want a baby returned to me. What does me being a U.S. citizen, not being a U.S. citizen, have to do with anything? So I just try to avoid the questions like crazy. Like I said, if you listen to Gordon's whole show about 2 weeks ago, he started cursing at me like I had drunk sailor. And he, in the beginning of the show, said, I've made a promise to my children that I won't curse no more. Man, he just ripped into me because he tried to play the judge. He tried to get me to say I'm a U.S. citizen. Do I have a driver's license? I said, what does that have to do with the matter at hand? That is totally irrelevant. Now you're just searching for, what are you doing? You're just fishing for an answer? What does this have to do with the matter at hand? I thought you said I was trafficking cocaine. I thought you said I was being busted with 10 pounds of cocaine or pot in my possession. What does this have to do with the matter at hand if I have a driver's license? Well, I want to know if you're a citizen. What does that matter? Can you tell me, is somebody claiming that by me having 10 pounds of cocaine in my house or in my car caused them an injury? Well, I want to know if you're a U.S. Sir, it's irrelevant. Is this a fishing expedition? What are we doing here? Is anybody going to claim that I've done them wrong? I will compensate them right now. Still is a moving party. There's no case here. There's nothing for us to talk about. Like I said to my mom all the time when we did the IRS stuff, can somebody make me exercise my left hand? No. Can the state force a pen in my hand and tell me exercise? Right, on that piece of paper, how much money you made this year? No. You can't tell me when to move my hand. I can exercise the right to not self-incriminate myself. And anything I write on that piece of paper, you're going to hold against me, right? Yeah, well, don't I have a Fourth Amendment right to not self-incrimination?
Okay, we've got people waiting in line with questions. Brandy, is there anything else you wanted to ask him? No, not at the moment. Thanks, Angela. Okay, thank you. Okay, Karl, take a breath.
Yeah.
You want to get a glass of water, maybe, or
drink a ton of milk?
Ew.
Oh, yeah. Don't go on there. I heard you terrific milk. Don't do it. Don't do it. I know your opinion of it, believe me.
Okay. Oh, gosh, I wish you'd bring it up. But anyway, take a deep breath. We have several people in line waiting to ask you questions. And you just go on and on and on and on and on and on and on. You got to take a breath once in a while.
Yeah, my eyes are popping. Go ahead.
Yeah, really. Okay. North New Jersey, go ahead. Did you have a question? Go ahead, North New Jersey. Did you have a question?
Yes, I did.
Go right ahead.
I heard you talk about common law courts. And, some people say there's no such thing as common law courts. Common law courts. Can you respond to that? Thank you.
That's simple. Because people say there's no Santa Claus, and they made a movie Miracle on 34th Street, and they proved in a court of record that there is a Santa Claus. As long as people believe it, it's true. So, like I said, that's one of the easiest examples you can give. But, like I said, if you go to federalcourts.gov website, it'll sure I can find it real quick. You look at the very first page, and it says, state courts are common law courts. So why would the federal government lie about something like that? Let me find it real quick. State courts. That's good. It'll pop up. Like I said, that's an easy link, and Karl actually printed it out. It's part of my exhibit. So if you read, if you go to Angela's website, and you, like I said, I'm giving her every single exhibit that I'm sending to the federal district court, and that's in a nice, colorful. It looks beautiful. The federal website is, they spent some big bucks on that. Let me see if I can find it real quick here, and I'll drop that link in there. But is there any other question while I'm doing this? Because this is the easy one for me to do. Just give you the link.
No, that was it.
Okay, yeah, because they don't bamboozle you with that nonsense. Yeah,
well, North New Jersey, are you on the chat? Can you see the link?
No, I'm on the phone now because I'm at work. But I was trying to get to your email last week, but for some reason I couldn't get to it.
Okay,
just go to our website, myprivateaudio.com, later on tonight, and I'll have all of his stuff posted and his contact information. Just go to the guest speakers page. Click on Karl Lentz. But if you want to go ahead and give your email out, Karl, go right ahead.
Yeah, let me give my email. It's JL DirecTV, the number 2, and
hold on, you said AL number 2.
Angela, can you give it to me so I can Google this?
It's KL, like Karl Lentz. That's his name. His first 2 initials. Mm-hmm. You said it was, what is it? KL what?
KL DirecTV with the number 2.
DirecTV. Number 2.
Yep, at gmail.com. Like Google.
At gmail.com. And I just typed it into the chat. So it's KL Direct TV 2 at gmail.com.
Let me give this man a little bit of price because I think I know what's going to happen to him. Oh wow, I found it. Here you go. It's www.uscourts.gov. Now it's a really long syntax, but I used to work at a computer company. But let me put it on the thing right now, and hopefully
are you typing it into the chat?
Yeah, I just put it in the chat.
Okay, good.
Pop through. But like I said, sir, if you just go to www.uscourts.gov. It's long. If you're listening to this, it's kind of tough. It's education. It's just like / educational resources / federal court basics / court structure / understanding federal and state courts .astx. And like I said, if you scroll down, it'll tell you the difference between a federal court and a state court. So if you could Google that if you wanted to, understanding federal and state courts, if you just did that, quote unquote, understanding federal and state courts, quote unquote, and then you do www.uscourts.gov, I guarantee it'll take you right to that page. Okay. And it's about 3/4 of the way down, and it just clearly says that all state courts are common law courts. And I'm glad you asked me a question. Well, I'm glad when people ask me questions instead of me just talking. Because what's going to happen is you're going to speak in open court and you're going to get nailed. Everything you do must be in writing before you get there. Like, I'm sure you've been arrested, I've been arrested. You know a public defender comes in and talks to you behind a cage. When they come to talk to you, they're going to say you're going to enter a plea. You ask them for a crayon, a pencil, pen. You write something down to that magistrate, and you don't utter one more word. And if you can, just back up the video or audio what I'm talking about tonight, and just like I said, drove Gordon Hall crazy, and Angela knows Gordon Hall's a real nice mellow man. So to drive him crazy, you better believe I must have really antagonized him. So he played magistrate, I played the defendant coming out of jail, 3 days being locked up, and this is exactly what I would do. I would present a notice to the court, and this is exactly what I'd write on the notice. If there's not a verified certified claim before this court at this time, I move to discharge all the charges against me immediately. For every second that you interfere with my right to go home, I'm charging you $1. The clock is ticking. What is your wish? So, like I said, it's got to be verified and not certified. Certified means it's just somebody acknowledges other than the person who wrote that paper exists. It's all certified. There's somebody else who recognizes that paper exists. Like, sir, I see it certified. I can see from here that paper exists. I don't need a certified stamp on it. I need this thing verified. And verify means by your voice. I need somebody to put their hand on a Bible in open court and say that that man, by his actions of having 2 tons of cocaine in the trunk of his car, caused me a direct injury, and I want compensation of $10,000. It's like, oh, is that all you want? Sure, I'll give you $10,000. Judge, can you give me 3 days to pay that man off? And if I don't pay him off in 3 days, you want to come and arrest me and let's do this again? I'll settle the debt with my brother. I got this covered. I'll figure out something. If I don't got the full 10 grand, maybe he'll accept me washing windows. Because the rule in law is, if I offer this man to wash his windows for 10,000 days, and he doesn't accept my 10,000 day offer to wash his windows, there's no longer debt between me and my brother. Because if he denies my acceptance of my payment of the debt, there is no longer debt between us. So that's something that you can study too, but that's a real fun, easy one to get out of every debt that anybody throws you at. Take him an offer.
But no, wait a minute. He doesn't have to accept you washing windows as payment.
Well, that's what
he can come back with a counteroffer and say, no, how about instead, you know,
that's
something else.
That's Gordon Hall, exactly. You listen to Gordon Hall. He'll say, okay, I'll accept the 10,000 days of washing windows, but that still does not negate the fact that I believe there's still a 10,000 debt between you and me. So that this time that doesn't satisfy the debt. But I'll accept that at this time. Now, I would also like you to start paying me $10. You got $1 a day to pay me for the next 10,000 days? I'll accept that. I did that in North Carolina court. I swear to God, it was so funny. The judge fined me $300. The only thing, if you ever look at my arrest record, my whole life is I got convicted of adding an artificial heat source to speed the fermentation of an alcoholic beverage. That's moonshine.
Well, you did what?
I added an artificial heat source to speed the fermentation of an alcoholic beverage. That was a federal for making moonshine. Because my wife and her family, they're a bunch of drunk Indians, so I did all the ingredients for free from the state, gave them all free flour and sugar because of the Indians. So I said, wow, we could make booze with this. So I actually got in trouble for that. So the judge gave me a $300 fine. And I wasn't really making much money at the time. The judge said, can you pay the $300 or 30 days in jail? I said, how about I pay you $5 a week for like the next 3 years? And he said, what? I said, do you not accept that offer? I said, are you refusing my payment? And the judge said, you know what? You go to the clerk of the court. Whatever you and the clerk of the court works out, you tell the clerk of the court, it's fine with me. So he understood the law. I made him an offer. I said, look, I don't have $300 at this time. Honestly, I don't. But I know I can come up with an extra $5 a week for the next 2 years. You accept that? And he was like, because he knows the law. Because if he says, no, I don't accept it. If he said the word no, he's the one who brought controversy into the public venue. He dishonored my proposal. The debt is no longer owed. So the judge knew I was playing with him. So the judge said,
well, I don't know. I think he could have come back with a counteroffer.
He did. He said, well, how would you pay half? And I said, I told you, my word is my bond. The best I can do is 5. You think I'm going to lie and say that I can really do 10 when I could do 5? You think I'm going to lie to a judge? He's like, well, okay, 5 is that's all I can do. That's my word. That's sticking to it. I'm not budging an inch.
Yeah, he didn't want to dicker with you anymore.
That's right. He's like, next case. No, he's like, yeah, let's see.
Okay.
That helps? All right, well, okay, Aunt, you got somebody else then?
Is that okay for you, North New Jersey? Was that it?
Yes, that was excellent. Thank you.
All right, thank you.
All right, check back later on the website or even in the archives of the chat here.
Yeah, I don't know if it pops in there. I'll type it again.
Okay, let's see here. We've got North and West Colorado. Go ahead.
Hi, Angela. Nancy.
Hi, Nancy.
I want to know how you can stop your former employer from sending a 1099 to the IRS.
How you? Well, for what?
Well, a 1099.
Yeah, how can you stop?
Yeah, it's a 1099-R. It's on retirement.
Uh-huh.
How do you stop them from sending that?
Well, let me see. He's sending a 1099 number. 1099 is a contractor. That's like a contractor
No, a 1099.
Oh,
Is how much so-called money you're getting from a retirement check.
oh, okay. And somebody's garnishing it or leaving, levying?
No, that's what they report that I received from the retirement.
Okay, so, I'm trying to say, your ex-boss.
Yeah.
Oh, I see what you're saying. What he's paying out to you through a retirement package. I see what you're saying.
Right.
Oh, and you don't want the federal government to be made aware of it.
Well, yeah, because I don't want to get involved in the taxes every time.
Okay, so are you still like filing like a 1040 form every January 1st?
No, I'm not.
Okay, so is there
But they're after me because of that.
who's after you?
The IRS.
Okay, and what is the IRS coming after you saying? What are they saying to you?
They're saying that they have made assessments, which they can't, because they've changed. They now turned me into a small business general contractor.
Because that's what the 1090 is. That's what I was saying. That's a contract. It doesn't make any sense.
And I'm not a contractor, and I'm not a small business.
So, like I said, what you need to do, the best thing for me, like I always tell people all the time, is like I say to them, look, well, I believe what you're doing is extortion. What I believe what you're doing is fraud. You notice the IRS. What I believe what you're doing to me is extortion. You're trying to claim that I owe a debt, which I do not believe I owe. And now some man's going to come forward into open court under oath of affirmation and swear on a stack of Bibles that I owe money. I will work a settlement with that man. But until that point, you know what? Honestly, I believe that you're trying to commit extortion, and I believe what you're doing is fraud. And if you don't cease and desist immediately, well, I'm going to submit a case against you in the common law court of record because you're causing me stress. And if you don't, if I get another notice like this, anytime any more correspondences come between me and you, I am going to charge you $10,000 for every time I get a letter in the mail.
Okay, now is that because 35 years ago I signed a W-4?
Nope. And any time you could just say, you know what? You're causing me harm. You're causing me injury. You're stressing me out. I don't wish to be stressed. I don't wish to be any aggravation from anybody. When my mailbox comes in, I better not see another damn letter from you. And this is what I would tell them. Exactly what I said. I don't know if you have to rewind it and do it again because Ann says I talk too much. But I just do what I just said. You just tell them that you are going to file a claim that you've been injured. You've been wronged. Because that's the biggest word in the law, is you've been wronged. That you believe that you're causing me stress and harm, and you do not have a lawful claim to any of my property. And if some man wants to claim right to my property, my money, let him come forth to a common law court of record, state his case in front of 12 judges, and maybe the 12 judges will find for that man. Because an attorney cannot speak under oath of affirmation in an open court of record. My sister, I'll give you a simple one. My sister did this to her ex-husband. She was getting divorced. My sister had no money because her husband hid all the assets. So he has a scuba shop and everything. He's got big bucks. So he had 3 attorneys plus a woman attorney. So she was smart to get a woman attorney to help defend him against the woman. So I wasn't able to get to New York, so I told my sister what to do on the phone, and she did great. What happened was when the judge started the court, I said to my sister, the judge is going to introduce the parties. So when you say to yourself, you say to the judge, say, I'm Karen Garner, and I'm here to present me and my case to the court. And the judge will say, okay, are you represented? And she says, just say, no, I'm here to present me and my case to the court. I've been aggrieved, and I'm here to a request from the court to create a constructive trust. That means it takes all his money and holds it in control of the judge, and the judge will dispense the money. A constructive trust is a really good one to do. So she said, okay, the judge said, I understand. So then the other side introduced themselves, and all the lawyers, my sister said, introduced themselves. And then my sister went first, and the judge said, okay, state your case. So she stated her case. Then the other side went, my ex-brother-in-law. And then the lady started to speak, and my sister said, I object. And the judge says, wait a second, you had your turn, now it's their turn. It's like, did my husband have a sex change? And they were like, what? I think I hear a woman talking. That's not my husband. And she was like, well, it is his attorney. He's like, ma'am, when I introduced myself to the court, did I say I was represented by an attorney? No. Did I say I was representing myself? No. I said I presented myself in the court, in the case of the court, right? She said to the judge, you know the rules, right? And she said, yeah, I know the rules. So she told the attorney to sit down. And the attorney lady's like, what? She paid me good bucks. She said, the judge said to the attorney lady, who was a lady judge, said, do you have any first-hand knowledge of the conversations or any of the events that transpired between that man and that woman during their marriage? And the lawyer lady said no. So then the judge said, well, then you know the rules. You need to sit down. He needs to speak. He needs to defend himself. So my sister just clobbered him because the judges, the attorneys aren't allowed to speak in an open court unless they have first-hand knowledge to the events that happened. And Mr. Cherry, if you go back on Angela's calls, look for Mr. Cherry. Mr. Cherry shows you how to knock the attorneys out of the box in 2 seconds. And I was doing this years ago. And Mr. Cherry did it like a year or two ago on Angela's calls, and I said, it does work. You knock the attorneys right out of the picture. So if the IRS tries to come to the court with an attorney, you knock the IRS's attorneys right out of the picture. I say, wait a second, this is a Commonwealth Court of Record. I'm presenting my case of an injury. I've been harmed, I've been injured by something or somebody called the IRS. Now, their attorney can't speak. Only IRS can speak. Oh, IRS didn't appear? Oh, then I guess I win the judgment. And it's a NIL, nil dissent judgment. The other side failed to speak. The other side failed to answer. The other side failed to tell the attorney what to do. I want my judgment, and I want it now. And it's over. So, it helped. But,
okay, cool.
You said, state court. Now,
yep,
in Colorado, where I am at the moment, state courts are really crooked.
right.
Most people say go to the federal court. Now, the federal district court claims that it is a court of record.
Every federal, if you could do it either way. It's either, you could Google the number 25. I'll type it on the board if you're looking on the board right here.
No, I'm not.
Okay, well, it's Cors Juris Secundum. You've heard of that, right? CJS?
Yes.
Okay, the second version of it. It's, you can just look under Federal Courts, Section 744. And, or you could look under Cors Juris, not the Secundum, the original one. That's volume 25, under Federal Courts, Cors Juris, volume 25, section 344. And it says, all federal district courts are courts of record. Period. Simple. So don't go into something called the United States Tax Court, the United States Claim Court, the United States Any Court. No.
I would never touch the tax court.
You just go to the federal district court. Everybody knows where the federal district court is in their state. So if it says, well, no, we call it the United States District Court. It's like, watch this. Let me call it the clerk of the court's office. And like, let me get this from. Yeah, ma'am, is this the federal district court? Yes, it is, sir. Okay, there you go.
Actually, there are codes of statutes that say that it's district court with little letters of the United States, not the federal district court is the territorial court.
Like I said, I gave a great example before. When I went to submit my lawsuit in 2009, they changed all the codes numbers around on me, so then I was actually saying I was a Vietnam vet not getting medical benefits. So all of a sudden they took all the Title 36 codes and they switched it over to Vietnam vet codes, and all the children codes they switched over to Title 65. So they switched all the codes on me. So I was like, you know what? How do I get away from their code world? I learned the common law court of record by watching Billy Thornton, and I said the only problem with Billy Thornton is he talks too much to the man in the black robe. He should just say, look, this is going to be done in 21 days. You're going to give me an answer. On day 22, I want your stamp of this court on this order, and it's done. Did people know how to appeal it? If they don't want to appeal it, I'm going to sell this judgment in about 20 seconds. So that's the summons to appear. You have 21 days to answer, or this order is final. And even if then that's it. You just deal with the common law court of record. You get rid of all these. I hear poor people like you asking all the time, and all these. I mean, nice Mr. Constitution man. He's giving you all these codes. He's giving you all these Constitution stuff. He's giving you all these citations. But I said Barack Obama won. I told you guys a month ago. I said when Barack Obama wins, he's going to put 2 more people on the Supreme Court, and every single thing that you used for the last 50 years of your life is going to be thrown out the window. So if you want to keep playing that the United States Supreme Court is the highest court of the government instead of the land, it's not the highest court of the land, it's the highest court of the United States government. The highest court of the land, and if you Google the word land, it says people, the people of the land. The highest court of the land of the people is the common law court of record. That's why it said, what's the characteristic of a federal court? Section 344, Cors Juris, volume 25. It says it right there. It said federal district courts and courts of record. End of the story. Why would I want to go into any other court other than a federal district court? And it's all low.
The United, they've changed they claim now that the United States and the United States of America are the same.
Well, that's what I'm saying is they changed it. You didn't change it. Like this is just said, well, we don't believe there's a common law courts anymore. We don't do common law courts anymore. It's like, so when did we become me? We is what? The judges and everybody here? That's fine. We is not me. When did the common law court outlaw? Can you show me? Of course, like I said, you see that in traffic court all the time. They'll say something like, well, is there a reason why I can't establish a case in a common law court of record and move the state prosecutor or the county prosecutor who's trying to prosecute a false charge that I went of a crime that I drove too fast? Is there a reason why I can't drag him into a common law court of record and bring him into my case?
Well, they're going to use municipal color of law.
Well, what they'll say is, well, we don't do the common law anymore. It's like, yeah, can you show me where the common law has been outlawed? Can you show me where it says somewhere that we do? Show me where it says that. Because I hear you saying that we don't do common law jury trials anymore. Can you show me where it's written down? It's like, okay, and it's like, well, there's that code. It's like, well, that's a code. That's not a law. Where is it outlawed? When did you throw away my Constitution? Because the 7th Amendment says if this is worth more than $20, I have the right to move a common law court of record. And once the jury comes down with a verdict, it can't be heard or retried by any other court in this land. Because that's what I say to people. Oh, that's a great thing to say to the judge. You say that to the judge. The judge starts going off on you about stuff. Say, Judge, if I lose, can I appeal this? And the judge says, yes, you can appeal it. Well, then I'm not on the court of record. Because in the common law court of record, under the 7th Amendment says once it's been tried by a jury in the common law court of record, it cannot be heard or retried by any other court in this land. So obviously, Judge, I'm in the wrong court. Because I would have...
What Constitution are you using? I mean, you're not a party to the Constitution.
That's right. You're not a party to the Constitution, but the state and the federal government are. And the state and the federal government says that this is a contract between the governments, that we will not interfere with the rights of man. And if anybody interferes with the rights of man has the right to come back and sue the government. The Constitution is just to protect our rights. It's just to make sure that the government doesn't interfere with our rights. That's all. We're not a party to it. I don't want to be a party to it. Because once you sign a contract, you relinquish certain rights to obtain privileges. So I don't want a privilege from anybody. My dad taught me this when I was a little kid. If you sign your name more than once or twice, you should be an honest man. It's an old saying. An honest man should be able to go through his entire life without ever signing his name. Because once you sign your name, you're relinquishing certain rights, and you're obligated to some other man. You're obligating yourself to somebody else. You're becoming like their slave. So everybody...
Okay, if you want to do something and you want to rescind all your signatures,
right?
You do it pro tunc to first.
Yeah. You just don't access to you. Like I said, if the IRS is coming after you and they try to say, well, are you a U.S. citizen? What does that have to do with me getting a letter in the mailbox? And I'm telling you, it's causing me stress. What does that have to do with me having a driver's license? What does that have to do with me having a Social Security number? What does that have to do with anything? Because no man is going to ever stand across you in a court of record. It's always going to be an attorney. So the attorney's not allowed to speak in a common law court of record. I told you what my sister did when the attorney tried to speak. And the judge told the attorney the rules. You know the rules. An attorney's not allowed to speak unless they have first-hand knowledge or witness something. So is that attorney going to say they have first-hand witness knowledge that you obtained the Social Security card at the time of your life? The attorney's going to be like, no. I have no idea if she's got a Social Security card or if she rescinded it or she revoked it. You guys are doing way too much paperwork. And like I said, I don't charge a dime to help anybody. So you got to be careful. All these people who are teaching you this stuff and they're charging you money. You know what? I always say, how is that relevant to the matter at hand? Where is my common law court of record? And the judge tries to talk to me and said, can I appeal whatever decision comes from this court today? He says, yes, but I'm not in a court of record because the 7th Amendment says that if I'm in a common law court of record, I cannot appeal this. There is no retrial and there's no rehearing by any other court in this land. I want to go into a common law court of record, and I want to go there now, and I will only answer there. I'm not going to answer about Social Security cards. I'm not answering about tax returns. I'm not answering anything. Can I appeal it if I lose? Yes. Well, then I'm not under the 7th Amendment. You're not obeying your oath of office. Your oath of office says that you have to protect my right if I evoke the Constitution to say that I'm a man And if it's worth more than $20, I have the right to move this before a court of record. Where's my court of record? You took an oath, right, sir? Yeah. And that's what I always tell people all the time. This poor guy said to me, I think it's Tom Murphy, said he's suing a judge in, like, tax court. I said, she's not a judge. She's an administrating hearing officer. She's under the administrative capacity. It's like she works for Coca-Cola. So if you work for Coca-Cola, and Coca-Cola told you to come before an administrative hearing today, and Coca-Cola board of directors, and you try to say, well, I have the right to carry a gun. I got the Second Amendment right to carry a gun. She'll look at you. It's like, sir, this is Coca-Cola. This is an administrating hearing. I don't know what the hell you're talking about. Constitutional right. You work for us, you know. So like I said, when you people are like, well, the United States citizen, well, you work for them. You're you're like an employee. So you'll start saying, well, I got this right. You're talking to an administrating hearing officer. It's not a judge. She didn't have to take an oath of office to become a Coca-Cola hearing officer. She doesn't have to take an oath of office as she's an administrating hearing. So the easiest thing to say when any woman or any man who's wearing a black robe comes before you, say, if I lose, can I appeal this? And they said yes. Then I must be in an administrative court. Because under the court of record, I can't appeal it. It's over. It's done. The Seventh Amendment is very simple. There's nothing, like I said, there's nothing fancy about the Seventh Amendment. It's like one sentence long. And like I said, I'm typing that right now because, like I said, it's very simple. And the easiest way to get this all done with all these judges is just say, can I appeal the decision of the court today? And he says, yes, I'm on a court of record. Here you go. The Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States other than rules of the common law. There you go. So it can't be re-examined in any court in the United States, so I don't know where they're going to retry it. It's a very simple, Seventh Amendment is simple, and the Ninth Amendment is even simpler. The Ninth Amendment just says whatever rights man has before this contract was written between the federal government and states, man still has those rights. Those rights have never changed. So the Ninth Amendment is it's actually called a savings to suitor clause, and all that means is that it's an escape clause for a man who doesn't want to operate underneath that contract. So, like I said, the Ninth Amendment, nobody talks about the Ninth Amendment, but the Ninth Amendment is the most powerful amendment that we have to drag everybody into a common law court of record. Because it's like, look, I had the right to drag everybody into a common law court of record before this Constitution was created. I had the right to go before a jury before the United States existed in 1776. I had this right to have a trial by jury for the last 10,000 years. Just because you guys made a new contract between the federal government and the states doesn't eliminate my rights, because it's very simple. See, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The people always had a right to go before their community for a trial. And you go back to Hammurabi, you go back 10,000 years, you go back to cavemen. They always had a right to have other people determine whether or not they'd done wrong to each other and determine what the punishment was going to be. Way antecedent to the Constitution being enacted. So they're trying to say, well, now we have a Constitution, now we got to do it all this way. No, we don't. The people always got the right to do it the way we've always done it. Just because you guys came up with a new Constitution in 1793 doesn't mean we're going to forget about the old ways, how we always did things. And they said, okay, fine. Whatever rights you had to have, whatever trials you had prior to this Constitution, you know what? You still got that right to do that trial that way. So there you go. You always throw the Ninth Amendment at them. Well, it's really the Ninth Article. But like I said, you know, that's how you pin them in there. That's how you pin the judges in the seat, if you say it correctly.
There's a question on here. It says, did Karl say there are no fees to file in the court?
Yeah, that's if you Google, oh boy, no, that's going to be a hard one. If you guys Google, I actually had to find that in a book, and I cut copies. I scanned it out of an old law dictionary. But what it basically said was, let me just type and read it to people so I can do the actual sentence. Maybe they could just quote unquote it. Yeah, because I use this as an exhibit. Yeah, like I said, if you go to Angela's website, I'm giving her all my exhibits, and you could actually see what I presented to the judge, because I wrote a heck of a nice letter to the judge today saying a lot of people are going to be listening to me on the radio today. So,
you know, when you sent it to me, under what email did you send it to me? Because I can't find it.
Let me see. Shoot. See, sent mail.
Did you send it to me via Skype? Or did you send it to me in an email?
Huh. Yeah, I see what you're saying. I see my sister's thing. It didn't go through to you. That's weird. Yeah, so once... here it is. Hang on. Let me back it up. Let me,
what email name are you sending it to me under? The one we just put in the chat?
Oh, yeah. Karl TV. Yeah, too.
All right.
You weren't able to get it to that one?
I don't see anything from you with that email address.
Let me get the thing going here real quick.
And that's something that makes me crazy.
Yeah. Because like I said,
people have 20 different names. You know, the email's different. The username on Skype is different. And it's like, oh my God.
Yeah, no, that's why I try to stick with KL Direct TV or KL Direct TV 1, 2, 3. So that's how I always do everything like that. Here you go. The record is free to the people. Here you go. You can Google this thing. That's where I got it from. I got it from Tomlin's Law Dictionary, page 320. That's where I got it from. And how did it actually go? Let's see. Find in prison. Free of use of courts and not use of courts of record. Let's see. The free use of all courts of record are not of record. Those are the previous courts. Is to be granted to the people. And like I said at the very beginning, it says every court of record is the king's court in his right of the crown and dignity, though his subjects have the benefit of it, and therefore no other court has the authority to fine or imprison. And so let's see, right here. The free use of the court, the free use of all courts of record and not of record is granted to the people. So I actually pulled it out of Tomlin's Law Dictionary, 4th edition, page 320. So, yeah, so like I said, I don't care if you want to consider me a king, because in this country we're considered sovereign, so we're all considered on equal standing as the king. So if you want to call me the king, fine. You want to call me the people, that's fine. You want to call me the subject, that's fine, because the common law court of record is free to the king and his subjects. So call me a subject, I don't care. Call me a king, I don't care. As long as I'm getting in here for free, that's all I care about. I don't care how you define me like that. As long as I'm getting in here for free, that works for me. I'm not paying $350. Because like I said, I sent them a bunch of things like that today about, I gotta get that thing actually.
Okay, someone on the chat here is saying that they tried emailing you to the email address we typed into the chat and it was returned as undeliverable. So would you spell it out for me? Are there 2 T's? It's Karl, KLDIRECT, TV2.
There you go. I just typed it right there.
Okay, so there isn't 2 T's in there. It's only one, so it's not. It's KLDIRECTV 2 at gmail.com. All right.
Right.
So the first one we typed in there is incorrect.
Right. So like I said, I simple letter to the clerk today, and I said I write this for there are many of the land similarly situated who have listened to me a few times, who appear to be truly interested and have told me they are willing to follow along with this case and to witness the results. For I believe I have chosen a simple method to move my case to the court. I have chosen to appear before a federal district court in the capacity of a man agreed, making simple wishes and demands to order the restoration of my rights and to seek compensation of the declared wrongs. I said, that being said, I now present to this District Court of the United States of Mill, Alabama, my case. I, a man, wish and respectfully demand of this court, 1, file my suit. 2, to give me a case action number. 3, to deliver and close summonses to the wrongdoers. 4, please time and file stamp my original copies of the suit and mail it back to my address. 5, it is my wish to not be charged a fee, and I do not want to diminish my standing to that of a pauper. I want my standing to remain that of a man aggrieved. I do not believe I have been presented a bill for services rendered. See, they didn't give me a bill. Why should I pay them $350? Nobody gave me a bill. And then I said, I do not believe at this time any officer of this court can claim I owe this court a debt. Why? Because you haven't done anything for me. And then 3, I do believe that this court was created for the use of man and those of mankind to settle contentious matters in a civil manner without a fee. And their niceness went on to say, I declare I appear before this court to seek the restoration of my rights that are secured and protected by the United States Constitution. And as all of the officers of this court have bound themselves to the Constitution, I, as a man, call upon the officers of this court to perform their duties. That being said, if the officer of this court still maintains that I'm in error of my beliefs, I will accept their beliefs. Therefore, I have enclosed the $350 filing fee demanded of me from the clerk of the court. For this matter, a controversy between I and the government of the state of Alabama has gone on for too many years. So please just take the $350 as I need this case to move now. For once this case is settled, everything will be returned. I said, if you wish to allow me to proceed fee-free, please return the $350. And that's the letter I sent to the clerk of the court today. Just basically saying to her, I believe. Now, if you believe I have a false belief, well, then just take the $350 and let's get the show on the road. That's how I worded it to them. And I talked to the head judge. His name was Keith Watkins. He was the very head judge of the Federal District Court. I went right to the top. As soon as the clerk of the court gave me a little bit of nonsense yesterday, I said, look, I read the United States Supreme Court decisions where somebody said that the clerk of the court would not allow them to file on demand, that the clerk of the court was giving him a hard time to move his case into the court. So the man sued him. It went all the way up to the Supreme Court. The Supreme Court said to the man, why did you not go to the head man of that court? Why did you just keep dicking around with the court clerks? If you went to the top man of that court and he did not interfere with your rights, you would have had standing to sue and we could have gave you $1 million. But since you only dicked around with the subordinate people and you never let the man on top of the court realize that you were filing a claim and your rights were being interfered with, you have no case. So that's what I did yesterday. Oh, I recorded. Believe me, I videotaped myself talking to them on the phone. So I talked to 2 or 3 clerks of the court, and then I went straight up to the guy who's on, if you go to the Alabama website for the Federal District Court of Middle Alabama, it says Keith Watkins is the head chief magistrate, the head chief judge, the big Article 3 judge. I called up right to his secretary, and I started talking to a lady named Pat for about 20 minutes. And I told him, I said to her last night, I want to tell everybody in the talk show call that you were a really nice lady. So she talked to me for 20 minutes. And she says, you know you are talking to the head judge right now. I said, yes, I know, ma'am. You're his representative, and whatever I just said to you right now is going to go right to him. She said, yes, correct. So this is an ex parte communication. She said, I'm starting to get uncomfortable with how this is going. So she let me talk to her for 20 minutes. I said, that's okay. It's going to be in writing, and you'll have it by Monday. And that's the letter I sent them. That I do not believe that I have to pay the $350 fee, because I don't believe anybody could claim I owe them a debt. I don't think you people have done anything for me yet. Until I've seen something done, why should I pay for my meal until I've ate it, until it's been delivered to me? Why should I pay for something until you've actually done something for me? I don't believe I should have to pay first. So that's how I went about, like I said, that's how I went about trying to get fee free. So like I said, that's why I said to the lady, she said, so you're going to be on a talk show tomorrow? I said, yep. She said, oh, okay. So I said, I told her, I said, I'm going to tell everybody you're a really nice lady. And you were really polite. And she just started laughing. She was like, well, thank you. So like I said, I'm going to resend all the stuff to Angela again. I'm sorry about that to go through for some reason. I've seen that it went.
Yeah. Send it to me and I'll try to get it up on the website later on tonight. I'll have your name up there. It'll be on the guest speakers page.
Does anybody else have any kind of questions? Andrew?
No, that looks like it. We've gone over the 2 hour for 2 hours and 30 minutes. Well, we have one more from North New Jersey. Go ahead.
He's a good
guy. We're going to close it up.
All right.
Go ahead, North New Jersey. Hi.
Hi. I wasn't about to let him get away. I've been waiting here. I was wondering if there is any way that this could be related to a foreclosure for property taxes.
Oh, yeah. Well, you're saying with a foreclosure with property taxes? Yeah, like I always say, Billy Thornton was a really good guy. I don't know if you ever watched. Have you ever seen any Billy Thornton's videos?
Have you seen who?
Bill Thornton. Bill Thornton.
On YouTube?
No.
Oh boy, you got to watch his. His are all free, and they were all really good. Dean Clifford isn't what you really need to know. He's a little bit too technical.
Oh, I've seen Dean Clifford, yeah.
Yeah, if you understood him, you will definitely understand Mr. Thornton, because Mr. Thornton's 10 times easier to understand. Did you understand Dean Clifford pretty easily?
No, about the executor and the
the
triangles, yeah.
Right, Right, good. If you can understand that, you really understand Billy Thornton. The only problem with Billy Thornton is he's from California, not from New York. So New Yorkers, we don't mess around. We're going to come, we're going to slam, we're going to get it done, we're going home. California guy, everybody, he wants to like everybody. He wants everybody to like him. He wants to, I don't know, he drags things on. Just say it and let's do it. So like I said to the other lady, if you go back and listen to this thing the same way you do with the IRS, if somebody is claiming something that they want to take your property, only another man has standing in the court of record. So like I said, I just emailed this stuff to Angela. So if you see the way I stylized the governor of Alabama, like man, Karl Lentz, and then like verses, I didn't use the word verses, I just put a black line between me and him, and said man, Robert Bentley. So now it's man against man in the common law court of record. See, so now we both have equal standing. His employees hurt me. They took my kid. I believe they kidnapped my kid. So now I'm coming after him because he should have kept his crazy dogs in his property, on his yard, and they should have kept them away from my property. But they thought, well, we're the big cheese in Alabama. We can do whatever we want. We could let our dogs run wild and just take your property, take your children away, and kill all your animals. You kill your chickens. What are you going to do? Sue us? In Alabama court? Well, we run the courts. We are the court. Like, good, fine, I'll take you to federal court. And like I said, so that's what you want to do, is if somebody's claiming, and who helped a lot with that, Chappie. Chappie was real good like that too with me, when he was basically saying, who penned the document? So who was penning the document? Who took the pen in their hand and they said, Miss North New Jersey, you owe X, Y, and Z. You go after that man who put his name on the bottom of that document. And you say, good, you're going to stand under oath of affirmation in the common law court of record, and you're going to swear that I owe this amount of money. And you're going to be like, well, I'm an attorney, I can't claim that. And if you're off, like my mom told me, she said, you know, if I'm wrong, my mom was an IRS agent, if I was off by 1 penny, and I demanded from a man to pay $89,612.17, and he only owed 16 cents, she said, that's a federal felony. She said, I go to prison for a long time, because that's fraud and extortion. Because I'm telling somebody to pay something, and if it's off by 1 penny, it's fraud and it's extortion. So who's ever coming up with these crazy numbers throwing at you, he better be to the penny perfect. And he better be able to testify on the oath of affirmation. And like I said, if you go back to Angela's talk show things, I don't remember what episode she did it up on, Mr. Chariot, like a black man from New York, New Jersey, he shows you how to knock the attorney from the county, the state, the DMV, from the IRS, from the Visa, right out of the picture. So then you're standing in an empty courtroom. Because sure, there's attorneys. They might have 100 attorneys there. The best case that I always tell people all the time, everybody remembers George Bush versus Al Gore in 2000 with the hanging chair in Florida, right? This was a very simple case. They went to the United States Supreme Court. The United Supreme Court had ruled on that thing in less than 5 minutes. Because Al Gore, even though, like I said, his daddy owned Occidental Oil, and Al Gore was a billionaire, and he was the standing vice president of the United States, he was the vice president at the time they went before the Supreme Court. And he said, oh, well, you have hanging chairs, and look, we got millions and millions of hanging chairs, so I really won the election. They drove up to the United States Supreme Court with tractor trailers full of hanging chairs. They had hundreds, thousands, millions of attorneys on Al Gore's side to present their case to the Supreme Court. The Supreme Court said, is there one man who's willing to stick his hand in the Bible before the Supreme Court and said that his right was interfered with to vote because of a hanging chair, and can that man pick out one ballot out of that tractor trailer and identify that ballot as his and prove that that is his hanging chair on that ballot? And the attorneys try to use up all this legalese stuff and millions of documents and all kind of court cases and codes and citations. And Scalia just asked him, is there one man, just find me some like black guy from Miami, a homeless guy, who wants to come here in the Supreme Court and claim that his right to vote was interfered with by a machine. Until you bring that man forward to the Supreme Court, Al Gore, you have no case. Now you go back to Florida and let them do whatever they want to do. But I'm telling you right now, you have no standing before the Supreme Court of the United States, because there needs to be an injured party. So if you actually read the Al Gore versus George Bush case with the United States Supreme Court, there was no injured party. They had no case.
Well, you're saying that if the attorney doesn't have the principal there standing beside him willing to testify,
but there has to be an injured party.
That I owe him the money.
That's right. He's going to have to swear
okay.
that he's going to have to swear that his right, that his property has been interfered with by your actions or your inactions. And there's nobody who's going to be able to say, my name is Suffolk County, and because she didn't pay me the money that she promised me, I couldn't buy my kid a G.I. Joe doll with a Kung Fu grip this Christmas, so she's injured me. Nobody's going to be able to do it. They don't have a case. So don't answer their case as a defendant. Go back and listen to this thing. Make your own case that they're filing a false claim against you because there's going to be no injured party who's going to stand in their court.
Do I put that into the to the same court?
No. Oh, yeah, you can put it in the same court because anybody in a
In
black...
other words, don't answer their claim.
Well, if
Do my own?
Well, what you do want to make an answer, say, I believe you're filing a false claim. You don't...
Pardon?
You could say that you believe that they're filing a false claim against you, and yes, they might have the codes, and yes, they might have all kinds of stuff on the books that says this and that, but you still believe it's a false claim. You don't have to believe in Santa. You don't have to believe whatever they want to believe. You have your right to believe whatever you want. And this is what always gets people in trouble all the time. Thank God you asked me that question. Because I hear all these people saying, oh, well, they have no facts. They have no facts. They have no facts. Never argue the facts. When a policeman wants to say I did 900 miles an hour backwards down the street, on my roof, tires squealing, okay, I believe you. You have the right to believe whatever you want. Those are your beliefs. Now, I have the right to believe that unless there's an injured party, you have no case. And I actually won. I was trying to find that case number so I could give it to you guys as a Virginia case. And the judge actually was going to make me lose. And he was actually going to fine for the police. He was going to fine for the deputy sheriff. I said, whoa. What does the law say, sir? And he said, what law? I said, what law? Your law. And he started to read the law. Because I said I wanted to hand him the law, but he had his laptop on his desk, so he flipped it up. He says, Virginia Code, like 16.1363. What we're here today for? Me driving in reverse. What does it say? And he says, well, it's illegal to drive in the Commonwealth of Virginia in reverse. He says it's first offense, it's a $50 fine, 1 point off your license. Second offense, it's a $100 fine, and 3 points on your license. Third time, it's $500 fine and suspension of a license for a year. I said, oh, now what does the law say? He said, that is the law. I said, sir, read the footnote. What does the footnote say? He read the footnote. He says, it's lawful to drive in reverse in the Commonwealth if, and then he goes, blah, 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 blah. Huh. Case dismissed. I said, no, it's discharged, but I'm not going to get into the semantics now. I got things to do. I said, this thing could have been settled weeks ago when I presented the bill back, the summons back, the ticket back to the prosecuting attorney, but he said, he just laughed at me, and he said, the law says that you can't do it. I said, no. What the judge first read was, it's illegal to drive in reverse. What did the Code of Virginia of 1950 say in the footnotes? That it's lawful to drive as long as I do not cause an injury or damage to man or property. There you go. I said it's on the footnote of every damn driving violation in your book. So I said, it was so funny, man, because the prosecuting attorney, his last name was, I don't remember his name, H, it was a silly name. But so I'm going home. So it was so funny when I looked at all the state troopers sitting there with their little nice hats on their laps. I said to them, I said, you know what, sirs? I said, if my truck caught on fire, you'd be the first ones to pull me out. God bless you. I love you all. I said, but you know, every time you interfere with a man's right to travel, you're breaking the law. It might be legal what you're doing, but it's unlawful what you're doing. So I said, goodbye, folks. So I left the courthouse, and the deputy ran out and said, I've never lost. He said, I'm the traffic code enforcement officer of the county. I teach all the recruits. How did you beat me? I said, because the judge read the law. She said, what law? I said, you read it. I said, I'll try to give you the paper in court, and you laughed at me. You wouldn't read the law. I said, so you read it. I said, oh, while we're standing out here, let me give you notice. The next time I come through this county, doing 90 miles an hour, no, 900 miles an hour, and I'm doing it in reverse, and I'm reckless, and I'm going all over the freaking road. I said, if you ever interfere again with my right to travel, I'm going to sue you in your official and individual capacity. I said, I'm going to lean you up in this county for everything you got. I said, so next time you see me come through, do you remember my right to mouth? Just wave high. And he's like, how are you going to do it? I said, I know the law. I said, have a good day. So I said, I beat you once, I'll beat you again. So he's like, holy cow. So like I said, man, when you know the law and know how to deal with the common law compared to the legal codes, you'll win every time. If we were in Italy or France, or we'd lose. I would lose all the time, like that poor girl who got arrested for killing her roommate in Italy, and it was a big trial. It was like she had to live with a black guy, roommate, whatever, and her parents were like, the court system here in Italy is upside down. My daughter's guilty, and she's got to prove she didn't do it. I said, there you go. You're in a code world. That's the code world. You're guilty, and you got to prove you're innocent. And that's what they're trying to do here in America. They're trying to make this a code society, that we're all guilty, and we've got to prove that we don't owe the tax. No, you've got to prove this is common law still, and you have to prove I do, because there's an injured man or woman standing on that side saying, if I don't pay this money, they're not going to be able to support their family. So you're going to need to bring the injured party. This is still a common law land, but they're trying to bring the English, European style of court system into this land. And if we're not going to win by our voting for Barack, we're not going to win by elections. You know, we're not going to win by getting a good governor who's in the office or a good congressman. The only way we're going to win is by the courts. And the only way we're going to win in the court is if we rely upon the 9th Amendment and rely upon the 7th Amendment. And it says that we have the rights, long antecedent, before this government was established, that we had the right to live on our Gilligan's Island and have everybody judge us. We have the right to have a trial by jury of our peers. The government can't infringe with that right. I want a trial by my jury of my peers, and I need the injured party to come forth and testify in the oath of affirmation. Because you will get letters from Visa cards. My sister, somebody got one. I'm living in a house now, and they were military people, and they got a Visa card thing, and an attorney actually made an affidavit. I said to my sister, wow, look, an affidavit from an attorney. But the attorney's not going to be able to affirm this affidavit in open court. But they can send all kinds of nonsense affidavits to the court, and the courts will accept any papers he wants to put in, any paper you want to. They will accept every single document that the attorneys want to put in. Now, the whole trick is you tell those attorneys to stand in open court under oath of affirmation and swear to that. And they'll be like, well, we can't. That's right, you can't. But you can put all the documents in, so they try to trick you people into saying, well, look, he did an affidavit. I thought all these men were...
Why can't they swear?
Because they have no first-hand knowledge, because they're not a party to the case. Are you up in the area? You're in the New York area, right?
New Jersey.
Right.
Near New York, yes.
Right. So
Right at the border.
have you heard that for the last 2 years that there's not been one foreclosure in the state of New York, right?
Oh, I didn't know that.
You Google that, because the judge said if any attorney comes to court with any paperwork from a bank trying to foreclose on some little old lady, that attorney is going to be held liable for whatever that bank submits to the court. So, attorney, if you want to take the stand and put your hand on the Bible, on the oath of affirmation, and swear that you know for a fact that that little old lady owes Bank of America money, we'll take your testimony. Until then, that's going to be the rules of the game. So, like I said, Google that when you get a chance, that there has been no foreclosures in the state of New York for like the last 2 or 3 years, because the attorneys are terrified, because the judges aren't playing this nonsense anymore. They're sending little old ladies affidavits, but now the judge is saying, somebody like me or Mr. Cherry said to the judge, hey, make that attorney go on a witness stand and put his hand up and swear to that. They'll make the bank come forward. And they were like, we're not going to do that.
Yeah,
So
let's
then-
swear them in.
What, swear me?
Yeah, let's swear them in. Let's get them under oath, and let's put them on the stand if they're going to testify.
There's not been one foreclosure in New York in the last couple of years. Crazy.
Party only in common law.
That's right. Only a man can be injured in common law like that. That's right. Because only a man can verify. Not certify, verify. Google the difference between certified and verified, and you'll see what I'm saying. Because my whole entire case file has been certified by the clerks of the courts, 9 judges, 17 attorneys, all certified that it's genuine, perfect, and legitimate. It's ridiculous. Everything in there is total fraud and a total sham. All certification means is one person picks up a piece of paper and says, do you believe I have a piece of paper in my hand? Yes. Okay. Stamp that seal and just certify that I'm holding a piece of paper. Certified just means that the person believes that that paper exists. It doesn't mean anything on the document is true. It doesn't mean it. And like I said to people all the time with poor facts.
Karl, we need to cut it because we're 2 hours and 43 minutes in, and I've got to go tend to my son, and I'm exhausted. I don't know about anybody else.
Well, let me just...
I'm absolutely exhausted.
A lot of mental work listening.
Well, let me just finish that last thing saying, because I think that's incredibly important, like that lady said to me, a fact. Because people always get confused with this poor definition of the word. Because, like I said, any statement that can't be conclusively proven or disproven is not a fact. Okay, let's just say, I was born on Jupiter. I could say I was born on Jupiter. That's a fact. Albeit it's a false fact, but it's a fact. But then I gotta say, I remember being born on Jupiter. That's not a fact, because nobody can independently verify what I said. I can't verify what I said because I said, I remember being born. So you just gotta say, I was born on Jupiter. And until another man can come into court and claim, my claim is a false claim, that I wasn't born on Jupiter, my statement stands as true. So you guys gotta remember, there are two types of facts. False facts and a true fact. So just because somebody says it's the facts, and the policeman says, well, if it's for a fact that you did this, it's like, okay, it's a fact. I'm agreeing with you, it's a fact. To me, it's a false fact, but it's a fact. So you don't dispute the people's facts. You let the people believe whatever they want to say. You let them make whatever facts they want to say about you. You go, yeah. Well, my facts are this. Now, we're going to need a third-party impartial witness to testify whose facts are true, because I have equal standing in court. Just like I said about the black guy knocking the bumper off the church lady's bus. Both were equal standing. Both said the facts. Now, the thing that was missing was a third-party independent person to testify that that fact was true or false, and they didn't have one. So they had no case. So hopefully you guys will be able to just replay this thing. I was afraid I wouldn't have enough to say for 2 hours. I swear.
You crammed a whole bunch in here. Yeah, they're going to be listening to this thing over and over again because you go so fast, first of all, and you cover a lot of territory. And you really, we can do another one. You don't have to try to get it all into one call, but I guess
is it possible to speak with you on the phone?
Yeah, I guess if you want to, Ange, Ange got my phone number. So
no, I don't have your phone number. Where do I have your phone number?
Oh, I thought, so you just said...
If you
I can send you an email, and then we could exchange
do it
phone
by
numbers?
email. That's the best way.
I just put it on the thing. Oh, hang on a second. I'm sure one more time.
What should I put in the subject line?
Are you reading the chat board?
Text?
Oh, she's not on the... Are you on the chat board, Nancy?
No, I'm not.
Okay.
I'm on the telephone.
All right.
Well, do you know how to get an email address?
KL Direct without
KL
DIREC TV
TV2, the number 2.
Oh, TV2.
Gmail.
Gmail. Okay.
There you go.
Yeah, I got it. Okay.
Alrighty. And also, you might want to check the My Private Audio website tomorrow.
Okay, I definitely will.
Okay.
When are you going to have it up, Angela?
Tonight sometime. I'll try to get it up there, and then I'll put his contact information there also. So.
Yeah, tell the people.
That's it.
Yeah, Ange, tell the people to listen to it on Windows Media Player or VLC Media Player, because they could actually slow the speed down.
Yeah, well, I mean, they can fast forward or rewind. Yeah. I think they know. They know.
Alrighty, Ange. If I get the settlement, I'll let you folks know, because I'll be in Tahiti, so you'll never hear from me again. So.
Oh, wow. You can call us. You can do a talk to from Tahiti.
Go.
That'll work. You'll be able to afford the phone call.
All right. I'm glad everybody knows that makes sense.
Thank you so much for coming on and spending doing almost 3 hours sharing your information with us. That's really great. I appreciate it. And we'll do it again. I'm sure we'll have an update in the near future.
Yeah, I'll put the patient number online next week so you guys can follow the case through the court.
Okay, great. That'd be wonderful. All right, everybody. Good night. I love you. Take care of one another. See you Saturday on Protectors of Liberty. Oh, we're not doing a Protectors of Liberty call on Saturday morning. We're doing, Greg Slaughter and Chappie are doing their webinar in lieu of the call for Saturday. So we'll see you then for that. And then Saturday night with Jack Bauer. And then we'll see you Sunday with John Stewart. And we do it all over again in a whole new week starting Monday.
Yeah, I was on Jack's call this Saturday. Yeah, he loved me. Yeah.
Well, good.
All righty.
We'll do it again soon.
All right.
All right. Good night, everybody. I love you.